ಡಬಲ್ ಸಿಮ್ ಕೊಡ್ತಾರೆ ಅದಕ್ಕೆ ICICI ತಗೊಂಡಿದ್ದು. ಆಕ್ಸಿಸ್ ತಗೊಳ್ಳೋದು ಒಳ್ಳೇದು ಅನ್ಸುತ್ತದೆ. ಮಾತಾಡ್ತೀವಿ ಆಕ್ಸಿಸ್ ಅಲ್ಲಿ ನಿಖಿಲ ಅವಳೆ ನಿಖಿಲ ಇದ್ರಲ್ಲಿ ಯೂಸ್ ಮಾಡಕ್ ಹೇಳಿ.
ಇಲ್ಲಿ ಬರ್ತಾ ಇದ್ದೇನಾ? ಇಲ್ಲಿ ಬರ್ತಾ ಇದೆ. ಇಲ್ಲಿ ಬರ್ತಾ ಇದೆ. ಇಲ್ಲೆಲ್ಲರೂ ಸ್ವಲ್ಪ ಸೈಡ್ಗೆ ಹಾಕ್ಬಿಟ್ಟು
ಮಾತಾಡ್ತೀವಿ.
ತಿರ್ಗಿ ಹತ್ತೋದ್ರಕ್ಕೆ ಇಲ್ಲೇ ಇರ್ಲಿ ತಿಳಿಸಿ.
ಇಲ್ಲ
ಸರ್ಕಲ್ ಬಂತ
ಇಲ್ಲಿ ಬರ್ತಾ ಇದೆ.
ಬಾರಿ ಐತಲ್ಲ
ಇಲ್ಲ ಹಾಕಿಲ್ ಸ್ಕೂಲ್ ಹತ್ರ ಕೇಳಿ
ತಿಳ್ಕೊಳ್ರಿ.
ನೀವು ಓಡಾಡ್ರಿ, ನಾ ಅಷ್ಟೊಂದು ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. ಇದು ಸ್ವಲ್ಪ ನಮ್ ಜಡ್ಜು ಸ್ವಲ್ಪ ತರಲೆ ಮನುಷ್ಯ. ಯಾಕ ಕರೆಕ್ಟ್ ಇಲ್ಲ ಕೇಳ್ತೀನಿ. ಇಳಿತೀರಿ? ಇಲ್ಲ ಬೇಡ, ಇಲ್ಲೇ ಇರ್ಬೇಕು. ಅವ್ರು ಅಲ್ಲ, ಅವ್ರು ಇಳಿಯಂಗಿರಿ, ಇಳಿದು ಓಡಾಡ್ಕೊಂಬರ್ಲಿ. ಒಂದೆರಡು ನಿಮಿಷ ರಾಜಣ್ಣ ಓಡಾಡ್ಕೊಂಬರ್ಲಿ, ಅಷ್ಟೊಂದು ಮುಗಿಸ್ತೀವಿ. ಆಯ್ತು.
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್
ನೋಡಿ, ಇದು
ಏನು ಈತ ವೇಷಿಂದ ಕಾಲು
ಸ್ಟ್ಯಾಂಡರ್ಡ್
ಒಂದು ಅರ್ಧ ಗಂಟೆ ಇದು
ಸ್ಟ್ಯಾಂಡರ್ಡ್.
ಇದೆ ಬದು ಹುಡುಗರ್ನ ಹಾಕೊಂಡ್ಕೊಂಡಿದೆ ಬದು.
ಏನ್ ಮುದ್ಕನ ನನ್ಕಿಂತ ಚಿಕ್ಕ ವಯಸ್ಸು. ನನ್ನ ಅನ್ಕನ ಎಷ್ಟು 6-7 ವರ್ಷ ಮೇಲೆ.
ಗಾಡಿ ಆಫ್ ಮಾಡ್ಬೋದಾ?
ಆಫ್ ಮಾಡು.
ಕ್ಲಾಸ್ ಇಳಿಸ್ಬೇಕಾ ಬೇಡ?
ಕ್ಲಾಸ್ ಇಳಿಸು. ಬೇಡ ಈಗ ಇದು ಇರ್ಲಿ. ಈ ಕಡೆ
ಗಾಡಿ ಬರುತ್ತೆ.
ಅದು ಬಾಗಿಲು ಹಾಕ್ಬಿಡಿಸ್ಕೊಂಡು.
ಚೆನ್ನಾಗಿರ್ಬೇಕಾ ಬೇಡ?
ಇಲ್ಲ ಬೇಡ. ಒಂಚೂರು ಮುಂದ್ಗಡೆ ಗ್ಲಾಸ್ ಸ್ವಲ್ಪ ಆಫ್ ಮಾಡ್ಬಿಡು. ಗಾಡಿ ಆಫ್ ಮಾಡ್ಬಿಡ್ತು.
First VC submissions ಇರುತ್ತೆ. VC submissions ಆದ್ಮೇಲೆ ಇಲ್ಲಿ ಮೆಮೋಸ್ ಲೆಫ್ಟ್ ಇಂದ ರೈಟ್. ಮೆಮೋಸ್ ಆದ್ಮೇಲೆ ಇಲ್ಲಿಂದ submissions ಲೆಫ್ಟ್ ಇಂದ ರೈಟ್. ಮೆಮೋಸ್ ಅಲ್ಲಿ ಅರ್ಜೆನ್ಸಿ ಫೀಡ್ ಆಗಿರಬೇಕು. ಅರ್ಜೆನ್ಸಿ ಫೀಡ್ ಆಗಿರ್ಬೇಕು ಸರ್. ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಾವು ಹೋಗಲ್ಲ. ಸೆಂಟೆನ್ಸ್ ಬರೀ ಬಂದ್ರೆ ಏನಾಗುತ್ತೆ ಆಗಿಲ್ಲ ಅಂತ. ಸರ್ ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಇದೆಯಾ? ಟೋಟಲ್ 8.
ಹಲೋ,
ವಾಯ್ಸ್ ಕ್ಲಿಯರ್ ಇದೆಯಾ ಸರ್?
ಹಲೋ,
ಕ್ಲಿಯರ್ ಇದೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು.
Mentioning through video.
Serial
Hello.
number 40 Millards.
40.
I have received papers yesterday, Millards. May kindly grant 1 week time, Millards.
I'm just appearing for the petitioner stating that they received the paper only yesterday. It is for a week's time. A week's time is produced granted. Yes.
Oblige.
my lord, serial number 3 orders.
Make a mention
Hello.
of the matter. Yes.
Serial
Next.
number 3 orders, my lord.
Make a mention of the matter reaches. Yes. Memos from the left side. Yes. What is the offense? One Monday. Yes.
This is also under 38 law. Sentence I saw. Builder please issue.
Yes, Monday. 138. ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ? ಎರಡರಲ್ಲಿ ಅದನ್ನು ತಗೊಳ್ಳಿ. Is the matter provided any interim prayer is sought for on Tuesday? Is the matter provided any interim prayer is sought for? ಅದನ್ನ ಅವ್ರು ಬರ್ಕೊಳ್ತಾರೆ, ಅವ್ರ ಕೆಲಸ, ಅವ್ರಿಗೆ ಅದಕ್ಕೆ ಸಂಬಳ ಇದೆ. Yes.
No, 138 matters, and yesterday I moved the memo. Today matter is listed before the bench, but it's not listed before the bench. I moved the new memo.
No. Was it
For the
scheduled?
suspension of the
Was it scheduled to be listed today?
day before yesterday I moved the memo. Today date is fixed for the suspension of sentence, but matter is not listed.
That's what I'm telling. I'm asking you whether the matter was scheduled to be listed today.
Yes, sir.
If it was not scheduled to be listed today, I am imposing 5,000 rupees fine upon you. You cannot dream something what is not there on record.
Tomorrow, Your Honor. Because the 30 days.
No, I am making it very clear that in my court, if once I say that it shall be listed on so and so day, Surya Paschimnal huttidru matter bartade.
Date is mentioned yesterday, day before yesterday, I see the.
5,000 rupees if your submission is not correct.
Tomorrow list the matter.
Learned counsel. A memo mele sharabari. Learned counsel submits that though the matter was moved and the matter was ordered to be listed today, the same has not been listed today. Court specifically asked the learned question as to whether the matter was directed to be listed today. Otherwise, the court may consider imposing a fine of not less than a sum of rupees 5,000 for making an incorrect submission. Still, the learned counsel for the petitioner adheres to his submission and says that matter, though directed, has not been listed today. Learned registrar judiciary to look into the matter and make his written submission in this regard. In case if the matter was scheduled to be listed today but not being listed, list the matter. Nale date haki on 1/12. Otherwise, list it on the day scheduled to be listed with the explanation, highlighting the explanation. Yes. Or ಹೆಸರು ಬರ್ಕೊಳ್ಳಿ ನಿಮ್ಮ ಹೆಸರು ರೋಲ್ ನಂಬರ್ ಕೊಟ್ಟು ಹೋಗಿ. Yes. 1 minute. ಯಾಕ್ರಿ ಯಾಕೆ ಹಾಗಾಗ್ತಾ ಇದೆ? You bring the concerned person, official, say who is in charge of the wording, posting the matter with the consent registrar to my chamber at 1:30 sharp. Yes, it will be listed tomorrow if it is not, if it is due for listing. No need to file a memo or number ಬರ್ಕೊಂಡಿರಿ. Yes. Yes.
The trial court imposed the punishment of to pay the 250,000 towards the to the complainant.
What is the offense?
138.
Yes. Now, what is the urgency?
Because they're likely to arrest the petitioner. They are because of labor.
No, have you sought for an interim order,
I have sought for-
suspension of sentence? But ಅದನ್ನು ಹೇಳಿ ಒಂದು sentence ನಲ್ಲಿ with respect to 138 NI Act offense, I have prayed for an suspension of sentence. ಅಷ್ಟೇ. Yes, ತಗೊಳ್ಳಿ ಮಂಗಳವಾರ next. Next Thursday. Yes. Yes, please. ಹೇಳಿ ಬೇಗ.
Your respondent. So final hearing. So you can post-
ಏನ್ ಮ್ಯಾಟ್ರು? ಯಾವ ವರ್ಷದ್ದು?
130,
ಯಾವ ವರ್ಷದ್ದು? Which year?
2021.
ಬರಲ್ಲ. We are in 2013-14. Yes. What is the offense? Whom you appear for? No, you are for the petitioner, accused. What for? Extension of Tuesday.
No, they have sought bail and for final disposition pertaining to year 2015.
2000, move the matter in the next week. Yes. Serial number 30. Yes. We will vacate the stay if any and grant you the time. ತೊಂದರೆ ಇಲ್ಲ, ವಿಲ್ ವೆಕೇಟ್ ದ ಸ್ಟೇ. ಕೇಸ್ ಬಂದಾಗ ಅವ್ರು ಊರ್ ಬಿಟ್ಟು ಹೋಗ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಾವೇನ್ ಅನ್ಕೊಳ್ಬೇಕು? 4 ವರ್ಷ ಹಳೆ ಮ್ಯಾಟ್ರು. ಸಂತೋಷ, ಹೋಗಿ ಬರ್ಲಿ, ನ್ಯೂಯಾರ್ಕಿಗೆ ಹೋಗಿ ಬರ್ಲಿ, ಬೇಡ ಅಂತ ಯಾರಂದ್ರು? ಒಂದೋ ನಿಮ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟು ಹೋಗ್ಬೇಕು. ಒಂದು ಅಂದರ್ ಬಾಹರ್ ಮಠ ಆಡ ಮಾಟ್ರಲ್ಲಿ ವರ್ಷ ಎಳ್ಕೊಂಡು ಹೋಗ್ತೀರಿ ಕೇಸ್ ಅಂದ್ರೆ. The request of the learned counsel for the petitioner who submits that his senior is not in station as a final opportunity, a week time is granted, making it clear that no further adjournment would be granted in the matter. Yes. Yes. No, by 2:30 we will take you report the settlement. You had 4 years time to find out possibility. Even now you are attempting to show any possibility of settlement.
Party was not reachable, not therefore I have instructed the council in the board will therefore we don't find.
The last time also I had taken time on the same ground of alleged possibility. Learned counsel from both sides present. Whom you appear for? You are for, yeah. Is there any possibility? ನೀವು ಒಂದು ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅಲ್ಲ ರೀ, ಈಗ ನೀವೊಂದು ಪ್ರಪೋಸಲ್ ಕೊಡ್ಬೇಕಲ್ವೇ? ನೀವು ಅಕ್ಯೂಸ್ಡು ಒಮ್ಮೆ 10 ಲಕ್ಷ ರೂಪಾಯಿ ಫೈನ್ ಅಮೌಂಟ್, ನಾನು 20 ರೂಪಾಯಿ ಇದೆ ಜೇಬಲ್ಲಿ ಕೊಡ್ತೀನಿ, ಏನೋ ಒಂದು ಹೇಳ್ಬೇಕಲ್ವೇ? As finally a week's time is repeated either to force settlement or to proceed. Yes. Yes. Whom you appear for? Yes.
There is a discussion going on, whether 6 lakhs already deposited in the trial court. Yeah, negotiations are going on. Chennai.
Who appear for respondent? At the request of the learned counsel for the petition, 10 days time as spread is granted for reporting the settlement. How to proceed? 28. Yes. Yes. The request of the learned counsel for the respondent. 2 weeks time as spread is granted. It's the matter now. Hold. As spread. Yes. 2 weeks degree. Short time as spread is granted. Hold. Yes. Make the mention the matter reaches. Yes. Call the matter.
Non-compliance of office applications. First time, Till Bhavan, Keshamurthy B.
I pray for 2 weeks time, my lord, for.
What for the time is?
Need to.
Ultimately, either today or tomorrow, you have to seek for a conversion.
Yes.
ಅದಕ್ಕೆ ಟೈಮ್ ಯಾಕೆ ಬೇಕು? ಒಂದು ಸೆಂಟೆನ್ಸ್ ಒಂದು ಮೆಮೊ ಬರೆದು ಜೂನಿಯರ್ ಹತ್ರ ಕಳಿಸಿದ್ರೆ ಆಗತ್ತೆ. ಅದಕ್ಕೂ ಕೇಶವಮೂರ್ತಿಗಳಿಗೆ ಸಮಯ ಬೇಕು. ಪಾಸ್ ಅವರು ಮಾಡಿರ್ತೇನೆ ಒಂದು ಮೆಮೊ ಕಳಿಸಿ.
Please, man.
Request of the learned counsel for the petitioner who submits that he is filing a memo seeking conversion of the matter, the matter is passed over as per. Call at 2:30 p.m. Yes.
Please, man.
Second time, serial number 2, Niranjan BP.
1 week finally. Yes, next.
Serial number 3.
My lord, in this case, I filed application for stay. Hello.
Complete office objection. There are few office
I
objections.
file application, separate application for suspension, my lord, 1 week's time.
Request of the learned counsel for the petitioner. Time a week time granted to complete office objection. Yes.
Serial number 4, Raj Prabhu S.
1 week finally.
Much
Serial
obliged.
number 5, Srinivas N.
There no requirement to pay or to move. Getting the matter listed has not come. No reasons of so. 100 rupees LSC. Okay. Yes.
Serial number 6, Somshekhar N.
So finally 1 week, 6, 7, 8.
Serial number 9, Vasant Kumar B.
Counsel for the petition is physically present. Files same. Going to seek conversion. Withdrawal ಬೇಕಾ ಕನ್ವರ್ಷನ್ ಬೇಕಾ ಆರ್ಡರ್ ಮಾಡಿ ಕೊಡಿ ವಿಡ್ರಾವಲ್ ತೆಗೆದು ಕನ್ವರ್ಷನ್ ಹಾಕಿ ಫೈಲ್ಸ್ ನಾವು seeking conversion of this resolution petition into a criminal appeal. Registry also has module full signature ಮಾಡಿ correction. Registry also has raised an objection on the maintainability of the present petition in the present form. In of the office objection, the memo filed today in the supporting submission. Conversion of this criminal revision petition into a criminal appeal as sought for is granted. The registry is directed to accord the conversion requested for, however, subject to the further scrutiny to be made by the registry if in the matter. Yes.
Serial number third time, 10, serial number 10, Raghavendra K.
Rejected.
Yesterday I appeared in this matter of this. Only 10 minutes I will compliment.
Rejected.
You have a petition considered.
ಎಷ್ಟು ಸ್ಪೀಡ್ ಅಲ್ಲಿ ಬಂದ್ರಿ 1 week time may be granted. ಅದೇ ಜೋಶ್ನಲ್ಲಿ ಹೇಳಿದ್ರೆ ಅದು ರಿಜೆಕ್ಟೆಡ್. ಎಲ್ಲ ಆಪರ್ಚುನಿಟೀಸು ಆಗಿದೆ. ಒಂದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳಲಿಕ್ಕೆ ಒಂದು ನಮೂನೆ ಇರ್ತದೆ, ಒಂದು ತರೀಕ ಇರ್ತದೆ, ಒಂದು ಹ್ಯೂಮಿಲಿಟಿ ಬೇಕು. ಅದಕ್ಕೊಂದು ಕಾರಣ ತೋರಿಸ್ಬೇಕು. ಬಹುಶಃ 8 ಸರ್ತಿ ಸತ್ತವ್ರನ್ನು 9ನೇ ಸರ್ತಿ ಸಾಯಿಸ್ಬೇಕು. ಇಲ್ಲದ ಕಾಯಿಲೆ ಬರೆಸ್ಕೊಂಡು ಹೋಗ್ಬೇಕು, ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿದ್ದಾರೆ ಅಂತ. ಅಥವಾ ಊರಿನಲ್ಲಿ ಕೆಳಗಡೆ ಕ್ಯಾಂಟೀನ್ ಅಲ್ಲಿ ಇದ್ರು ಡೆಲ್ಲಿಗೆ ಹೋಗಿದ್ದಾರೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ಅಂತ ಹೇಳ್ಬೇಕು. ಯಾವ ಆಪ್ಷನ್ ಬೇಕು ನಿಮಗೆ? ಎ ಬಿ ಸಿ. ಕಷ್ಟ. 4 days ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಆಯ್ತು. Yes.
Orders matter, serial number 11, E.R. Pankajamani, S. Vishweshwaraya, correspondent.
That advocates on record in the family matters. Because of that, on the other side also. Regarding mental abilities.
ಹೆಂಡತಿಗೊಂದು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡೋದ್ರಲ್ಲಿ, ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡೋದ್ರಲ್ಲಿ 11 ವರ್ಷ ಡಿಲೇ ಮಾಡ್ತಿದ್ದೀವಿ. 11 years. ಪಿಟಿಷನ್ ಗಿಂತಲೂ ದಪ್ಪ ಆರ್ಡರ್ ಶೀಟ್ ಆಗಿದೆ. ಪಿಟಿಷನ್ ಗಿಂತಲೂ ದಪ್ಪ ಆರ್ಡರ್ ಶೀಟ್ ಆಗಿದೆ. ಲಾಸ್ಟ್ ಟೈಮು ಅದೇ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳಲಾಗಿದೆ. Request of the proxy counsel of the petitioner who submits that there is a death in the family of the learned counsel for the petitioner on record as a final last chance. A week's time is granted. comply office subjection. Otherwise, the court may proceed to pass appropriate order, including dismissal of the petition on maintainability. Yes.
Serial number 12, Reddy Lingappa GM.
I paid for the petitioner in this case, my lordship. One small submission, my lordship. The respondent address is proper ಆಗಿ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತ ಸ್ವಾಮಿ. So that's the reason petitioner ಗೆ health condition ಬೇರೆ ಸರಿ ಇಲ್ಲ ಸ್ವಾಮಿ. Please time may be granted, my lordship. 1 week, my lordship. I will comply the furnishing fresh address, my lordship.
ಎರಡು ಹಿಯರಿಂಗ್ ಡೇಟ್ ನಿಮಗೆ ಅದೇ ಉದ್ದೇಶಕ್ಕೆ ನಾನೇ ಕೊಟ್ಟಿದ್ದೇನೆ.
ಹೌದು ಸ್ವಾಮಿ.
Forget about the previous roster. I myself has granted you 2 adjournments for the very same reason. I will grant you 1 more adjournment provided you pay the cost of my time spent on this matter. What is equivalent to my salary, you pay that as a cost.
Please, my
I grant you time.
Please, my short
Because you
accommodation,
are really wasting my time, the precious time of the court,
please, my lord.
for no valid reason. I don't deny you the time, but I impose the cost equivalent to my salary for every hour.
Please, my lord. Petitioner health condition ಬೇರೆ ಸರಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಅಂತ ಸ್ವಾಮಿ. ಒಂದು ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್, my lord. Finally, last chance, my lordship. I will. He is a school teacher, my
Video conference.
respondent school teacher, my lordship. Because of so that's the reason, my lordship.
ಈ ಸ್ಕೂಲ್ ಟೀಚರ್ಗೆ ಫಸ್ಟ್ ಬದ್ಧತೆ ಬೇಕು, ಪ್ರಾಮಾಣಿಕತೆ ಬೇಕು. ಅವ್ನ್ ಸ್ಕೂಲ್ ಟೀಚರ್, ಇವ್ನು ಆಟೋ ಡ್ರೈವರ್, ಇವ್ನು ಕೂಲಿ ಅಂತ ಹೇಳಿದ್ಕೊಳ್ಳೆ ಅವ್ರಲ್ಲಿ ಪ್ರಾಮಾಣಿಕತೆ ಕೊರತೆ ಇದೆ ಅನ್ಕೊಳ್ಬೇಡಿ. ಇಲ್ಲಿ ಬಂದಿರೋದು ಪ್ರಾಮಾಣಿಕತೆ.
Please, my lord.
ಅವರ ಮುತುವರ್ಜಿ, ಕಾಳಜಿ ಮತ್ತು ಅವರ ವಕೀಲರದ್ದು ಕೂಡ.
Please, my lord.
ನಿಮ್ ಕಕ್ಷಿದಾರರಿಗೆ ಅದು ಗೊತ್ತಿದೆಯೋ ಅಲ್ವೋ ಇಷ್ಟ ಈ ಪಾರ್ಟಿ ಅಡ್ಜರ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂತ ಅದು ಅನುಮಾನವೇ.
ಇಲ್ಲ ಸುಮ್ಮನೆ
ಸುಮ್ಮನೆ ಇಲ್ಲದ ವಿಷಯನ ಇವ್ರು ಸ್ಕೂಲ್ ಟೀಚರು, ಇವ್ರು ಆಟೋ ಡ್ರೈವರು, ಇವ್ರು ಕೂಲಿ, ಇವ್ರು ಈ ಜಾತಿಗೆ ಸೇರಿದ್ದಾರೆ, ಇವ್ರು ಮೈನಾರಿಟಿ ಕಮ್ಯುನಿಟಿ ಯಾಕೆ ತರ್ತೀರಿ? ದೇ ಆರ್ ಆಲ್ ಟೋಟಲಿ ಇರ್ರೆಲೆವೆಂಟ್.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್. ಸಾರಿ
ಮತ್ತೆ ಈ ಒಂದು sufficient opportunities had been granted to the petitioner to ascertain the correct, complete and present address of the respondent and to take first steps. The petitioner has not done the needful. And once again is requesting for time to grant some more time to do needful in the matter. Considering the fact that sufficient time has already been granted to the petitioner, though the petition could have been dismissed for not taking step, however, as a final last opportunity, a week's time is granted to do needful, but imposing a cost of ₹500 upon the petitioner, payable to the Legal Services Committee of this court within 2 days from today, and filing a complaints memo along with receipt to that effect in the registry within the time. Yes.
Serial number 30, Ramesh H.E.
ನಿಮಗೆ ಸಿಪಿಸಿ ಸಿಆರ್ಪಿಸಿ ಕೊಡ್ತೇನೆ, ಅರ್ಧ ಗಂಟೆ ಸಮಯ ಕೊಡ್ತೇನೆ. ನೀವು ಆಫೀಸ್ ಅಡ್ಮಿಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಇರೋದು 2 seconds. 2 seconds ಟೈಮಿಗೆ ಯು ಹ್ಯಾವ್ ಟೇಕನ್ ಸಫಿಶಿಯಂಟ್ ಟೈಮ್. 2 seconds 1 week ಕೇಳ್ತಾ ಇದ್ದೀರಿ. ಪುಸ್ತಕ ಇಲ್ಲದೆ ಹೋದ್ರೆ ನಾನು ರೈಟ್ ನೋ ಕೊಡಿಸ್ತೇನೆ. ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀರಿ ಮಧ್ಯಾಹ್ನದೊಳಗೆ. Counsel for the petitioner submits that he would comply the office subjection in the forenoon session. Registry is directed to permit him to comply office subjection. Call the matter at 2:30 p.m. Right now. Yes.
Serial number 14, Krishnamurthy D. Madhusudan MN for respondent.
Yes. Who made the submission seeking time?
Matter is settled.
Why don't I dismiss the petition for non-prosecution with cost by reproducing the previous 4 hearing dates observations made in the matter?
Last hearing that also mirrors submission date, but
Sir, last hearing date you were absent. ಏನೋ ಹೇಳ್ಬೇಡಿ, ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದೆ 4 ಹೇರಿಂಗ್ ಡೇಟ್ ಇಂದು ಬರ್ಸ್ತೇನೆ, ನಾನು ಕಾಸ್ಟ್ ಹಾಕ್ತೇನೆ. ನಿಮ್ಮ ಇಚ್ಛೆಗೆ ತಕ್ಕಂತೆ, ಸ್ಥಾನಮಾನಕ್ಕೆ ತಕ್ಕಂತೆ 5 ಸೊನ್ನೆಗಳು 6 ಸೊನ್ನೆಗಳು ಎಷ್ಟು ಸೇರಿಸಲಿಕ್ಕೆ ಹೇಳ್ತೀರಿ ಅಷ್ಟನ್ನು ಒಂದರ ಮುಂದೆ ಅಥವಾ ಎರಡರ ಮುಂದೆ ಇಟ್ಟು ನಾನು ವೆಚ್ಚವನ್ನು ಹಾಕುತ್ತೇನೆ. ಒಮ್ಮೆ ವಿಸ್ತಾರದಲ್ಲಿ ವಿಸ್ತಾರವಾಗಿ ದೆಹಲಿಗೂ ಹೋಗಿ ಬರ್ಬೋದು. ಎಲ್ಲ ಕೊಟ್ಟಾಗಿದೆ ವಕೀಲರು. ನಾನು ಈ ಪಾರ್ಟಿ ಮಾತಾಡ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿಯೇ ನಾನು ಮಾತಾಡ್ತೇನೆ. ಸೆಟ್ಲ್ ಆಗಿದೆ ರಿಪೋರ್ಟ್ ಮಾಡಿ ರೈಟ್ ನೌ ಮಾಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಇದೇ ಡ್ರಾಮಾ ಆಗಿತ್ತು. I am using the word drama because order sheet has recorded what has transferred on the previous date. No, I am dismissing the matter.
any date perhaps.
ಅಲ್ರಿ ನೀವು ಮತ್ತೆ ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಹಿಂದೆ ಕಕ್ಷಿದಾರರು ಕೂತಿರ್ತಾರೆ, ಅವರು ಅನ್ಕೊಳ್ತಾರೆ ವಕೀಲರು ಏನಪ್ಪ ಹೇಳ್ತಿದ್ದಾರೆ ಅಂತ. ಆಗ್ಬಾರ್ದಾಗಿ.
Any date perhaps.
Both side present, reiterating the submission made on the previous 3 dates of hearing. The learned counsel for the petitioner is reiterating repeating the same submission and seeks one more adjournment on the pretext of the alleged settlement. However, without reporting the settlement. As such, granting of any further time would be only upon cost. Thus, apart from reminding the parties of their liability to pay the graded cost in case if the matter is settled under section 147 of NI Act, which observation was also made on 14/10/2022, imposing a cost of ₹500 payable by the petitioner to the Legal Services Authority of this court within 2 days from today, and filing a complaints memo along with receipt to that effect in the registry to that within the said time. A week's time is granted. The last opportunity. Just a matter on 8/12. Yes.
Seal number 15, Ram Prasad SN.
Daily pass over the matter.
What ought to be passed over? You want the dismissal to be ordered in the presence of the counsel on record?
Daily process to them, that's what. Daily process to them comply.
Counsel for the petitioner is not physically present. This is high talk. ಪ್ರೋಸೆಸ್ ಕಟ್ತಾ ಇದ್ದಾಗ ಏನೂ ಮಾಡದೇ ಇದ್ದಾಗ ಆಮೇಲೆ ಇನ್ನೊಬ್ಬರನ್ನ ಕಳಿಸಿ ಟೈಮ್ ತಗೊಳಪ್ಪ ನಾನು ಪ್ರೋಸೆಸ್ ಕಟ್ಟಿ ಬರ್ತೇನೆ ನಿಧಾನ ಅನ್ಬೇಕಾದ್ರೆ ಅವ್ರು ಯಾವಾಗ ಕಂಡುಬಿಡ್ತಾರೆ ನೋಡಿ ಮ್ಯಾಟರ್ನಲ್ಲಿ. ಹಾಗೆ ಇಳಿದು ಬಿಟ್ಟಿದೆ ಈಗ ಪ್ರಾಕ್ಟೀಸು. ಏನ್ ಮಾಡ್ತೀರಿ? ದುರಂತ ಅದು. ಏನ್ ತಗೊಳ್ರಿ? ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ for passover of the matter. However, when the court specifically asked him as to why the matter is required to be passed over, the counsel submits that the counsel for the petitioner may pay the process today. Perusal of the order sheet will go to show that long back has been granted with the relief of the suspension of the impugned judgment, impugned order on sentence. However, on terms, till date, though he is enjoying the benefit of the interim order of suspension of sentence, has not evinced any interest to pay the process. asset. By vacating the interim order granted earlier, the time may be granted. However, imposing a cost of ₹200 payable by the petitioner to the Legal Services Committee of this court during the forenoon session and filing a complaints memo along with receipt to that effect in the court. 2:30 p.m. The matter stands passed over till 2:30 p.m. Ask him to come with the receipt. Yes.
Hearing on interlocutor application serial number 16, R.B. Deshpande for appellant 2 to 4.
State yesterday.
Na Krishnappa.
Yes, please.
17/2018. Worship, while admitting every on the get the application of appellant number 1 for suspension of the text.
Yes.
Later, nearly for 3 years, matter was not
Hmm.
I have read IA1 for early hearing. That was allowed on 1594.
Hmm.
That was office was directed to prepare the paper book and list the matter, usual books. This matter was paper book was not prepared. I have filed IA for a suspension of sentence on 29/6/2022. Then, after filing the second IA for suspension of sentence, paper book is prepared on 8/7/2022. Then I tried May 11th by moving memos before postal court, requesting them to issue the matter for final hearing. Memo since what has written post the matter in the usual course, therefore the honorable process cannot hear the matter of this.
Now, whether while allowing your IA for early hearing, did the court made any observation as to when the matter is directed to be listed
Usual.
in the usual? So when it said usual court, don't you think that you are still in the queue?
We will be in queue. Meanwhile, since at least 50% of the sentence is served by the appellant, only 10 years, and he is ready to pay. Even though his father is a good farmer, ready to deposit the pay amount. I am taking one more chance before God to reconsider my suspension of sentence.
Yes.
As sentence is concerned, along with the statement of objection, document number 1, and the lecture, the document number 1 clearly discloses that still the respondent accused, the appellant accused is required to serve 4 years 9 months imprisonment in respect of the text. So will that mean the case? That is the actual thing. Apart from that, with regard to the suspension of sentence is concerned, on which the earlier application was being heard and disposed of. Will that mean the case?
There are counsel from both sides present. Heard arguments from both sides and IA 1/22 filed by the accused number 1 under section 389(2) of CRPC. Second is enlargement on bail. Here's the memorandum of application and the objection filed by the CGP. Yeah. Only contention of the applicant as with the argument of the learned counsel for the petitioner is that though it is a successive bail application, however, even after following of the application of the applicant for early hearing, the matter has not been listed for final hearing as such. The final hearing further, paper book was also not prepared, and the petitioner has and the applicant has undergone the substantial portion of the sentence of imprisonment ordered against him. As such, he may be enlarged on bail. The prosecution in its objection, as with the learned CGP in his argument, while denying the contention taken up by the applicant, has stated that the contention of the applicant that he has undergone 80% of the sentence of imprisonment ordered against him is far from true, and he is yet to suffer the imprisonment of more than 4 years. Respondent also objected, stating that there is no change in the circumstance, the date of the rejection of his previous bail application. Next line. The only contention of the petitioner that the paper book has not been prepared by the registry does not hold good now, since the paper book are ready. However, the parties have not collected the same. The same is reflected in the order sheet as well in the cause list also by the registry. As such, the non-preparation of the paper book cannot be a change in the circumstance. Fair. Though it is a fact that IA 1/21 filed by the applicant for early hearing was allowed by this court, however, even according to the applicant and the learned counsel, the matter was directed to be listed in the usual courts. As such, the registry might not have listed the matter for final hearing. However, I am of the view that the same is also cannot be a ground for allowing the present application, considering that there is change in the circumstance. Where the alleged offense is the alleged kidnapping of a minor girl and subjecting her to rape and sexual assault by the accused. Under the such circumstance, I am of the view that the alleged non-listing of the matter for final hearing cannot be a change in the circumstance. Hence, the IA 1/22 stands rejected as devoid of merit. Registry to list the matter for final hearing in the last week of January 2020.
Bill number 17, Badranisa, SCGP for respondent.
January 2023. We will hear the matter the week after next. Yes. Copy ಕೊಡ್ರಿ ಅವರಿಗೆ 1.5 ವರ್ಷ ಆಗಿದೆ. Learned counsel from both sides. Learned CGP. Got the request of learned CGP for a copy of IA 3/21, the learned counsel for the petitioner undertakes to furnish the copy of IA 3/21. It's the matter of 3 weeks. Yes.
Bill number 18, Sanmati EI.
3 weeks as great. Yes. What is the offense?
Section 276.
276.
The TDS right does not be limited. The accused is the chief financial officer of the company, and he has been discharged under section 235 when application has been filed by the accused before the trial court on the ground that he was not a principal officer. The Honorable Court has not considered any of the documents filed by us. The court has intended to show that he was a principal officer. No documents are produced by the department, but we have produced the documents. It has not been produced at all.
Whether any instruction to the other side respondent is required to come from London.
Your Lordship, that is another case. He is one of that is in case of J. Malyan. We are trying to secure the blood.
So no necessity of an instruction to the other side from London. For the submission of the petition. There is the memorandum of petition being given on the issue notice to the respondent. In petition and on A1/22. The petitioner to pay the necessary process and furnish copies in the registry, if not already done, within a week from today.
Serial number 90, Sridhara T.
Order submission of Lorent Council for the petitioner on A1/22 filed by him under section 482 CRPC seeking filing of the order dated 59/2022, on which day this court had dismissed this petition for non-compliance of this objection. Now we are ready to complain.
There are about 18 office objections. Yes, my lord.
Why?
By Monday, I can't.
You should have complained by this time, right? Even after filing this recalling application nearly 2 months back, you are till date not ready to comply the office objection, at least today. Still you want 3 days time. Then why did you file this recalling application in advance? 2 months time is over, even after filing this recalling application. Application hakadu, recalling amel nodanante nidana during the course of the day. However, keeping pending IA 1/22, the day's time as prayed is granted to comply office objection in its entirety. In case office objection in their entirety, but in case list the matter wrong. 5, 12. Cannot go to the registry on 3rd December or the 2nd December, something like that. I have said within a day. You should go there and comply within a day.
Serial number 20, Nitin AM. Ananda AP for respondent.
Office of the DC I submitted. First DD that I gave got a third and another second DD that also I submitted to me. Which was raised in previous year, the other side submitted it. I have one more objection. When application filed with respondent.
Show me the DD, please.
Yes. Dated,
Good read, yeah, memo.
10th August.
for like 50,000 each. Supposed to pay for like 50,000.
Have you also copy of this IA to other side?
They were not present. One submission. I had furnished process matter. Notice was supposed to be issued. Notice was not issued to the other side. Later, the police report was out to file matter that the respondents are not available beside us. Upon which the respondent on council appears for respondent to files of Wakalam. The objection that was raised also was on IA number 1, which I had filed on the initial point for extension that the copy was not served. Now that the advocate is on record, I have served a copy of that to the advocate. The copies of the DD I have not furnished.
You have served the copy of IA to other side.
Yes, I have.
Admittedly, even according to you, even as on the date of seeking extension, you are not ready to comply the terms of the deposit.
Ready. Today,
As on the, understand the question, please. As on the date of the filing of this application seeking extension of time, then also you are not ready with the money.
I'm ready.
I am asking not present tense, past tense. You were not ready as on the date of filing this application, not as on today. ಯಾಕೆ ಪ್ರಶ್ನೆ ಅರ್ಥ ಆದ್ರೂ ಬೇಕಂತ ಅದನ್ನ ಅವಾಯ್ಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೋಡ್ತೀರಿ?
On the day when this application is filed, that is
DDs were not with you. You had not obtained DD. On a month after this application.
ಒಂದು 4/4/2022 ಒಂದು DD ಇದೆ. ಇನ್ನೊಂದು DD ಇರುವುದು 4/14/7/2022. For the extension filed also I had a DD. That also.
So that in compliance of the entire term of the condition, partial amount.
50% I had to pay.
Counsel for the petitioner alone present, learned counsel for the respondent not present. Learned counsel for the petitioner submits that copy of IA 2/22 has been served upon the respondent. Since the applicant of the petitioner is seeking extension of time of an interim order which was passed exactly 1 year back, I am of the view that a week's time would be granted to the respondent to file their objection if any to IA 2/22. As such, as finally a week's time is granted. Yes.
Serial number 21, Ashwath Narayana L.
2,80,000. When I came on the first time, 2,80,000 rupees I had deposited. After that, an amount of 4,50,000 rupees, total into 7,30,000 rupees becomes the 50% of the amount. So what I am supposed to pay is 4,50,000 rupees now to comply the entire amount. Because initially I had paid 2,80,000 rupees.
All this I will hear in the next week. I'm not rejecting your application now.
Number 21, Ashwath Narayana L. Abhishek K for respondent.
You are for the applicant. You have gone through this application before signing it. There is one more important correction. Have you, in the first page anywhere mentioned as to the rupee Floridian font, what those figures denote? Can that figure be treated as rupees? Always. Rupee Floridian bit hogide always. Turn to the second page, 11th line from the top. Old RS you have mentioned, right? Right. ಯಾವ್ದಾದ್ರು ಒಂದಿರ್ಬೇಕಲ್ವೇ ಎರಡರಲ್ಲಿಯೂ ರುಪಿ ಫರಿಡಿಯನ್ ಇದೆ ಅಲ್ವೇ ಅದನ್ನ ಹಾಕ್ಬೇಕಲ್ವೇ ಅಟ್ಲೀಸ್ಟ್ ಕೋರ್ಟಿನ ಬಗ್ಗೆ ಅಷ್ಟಾದ್ರೂ ಗೌರವ ಬೇಕಲ್ವೇ ಏನೋ ಒಂದು ಸೈನ್ ಮಾಡಿ ಬಿಸಾಕ್ತೇನೆ ಎನ್ನುವ ಮುಂಚೆ ನಾನು ಹಾಕ್ತಿರೋ ಸರಿ ಇದೆ ಅಲ್ವಾ ಅಂತ ವಕೀಲರೊಮ್ಮೆ ನೋಡ್ಬೇಕಲ್ವೇ have served copy to other side. They did not say no objection. Both of you submitted that the matter would be settled between the parties. The court said that 3,82,500 rupees graded cost is required to be paid in the matter. Speaking about graded cost. Graded cost or kodil sadhya illa. Kotri kese irolla. Yes. A release of the amount. Yes. You had given the two different court name. Yes. Order to the panel. But according to you, one portion was paid, deposited in trial court, another in sessions court. Your prayer was only to release the amount deposited in the trial court earlier, right? Joint application. The matter is listed. Based upon a memo or being spoken to filed by the respondent. There is the same. It is the summary of the memo as well the mentions made by the learned counsels that though this court has ordered for the release of a sum of ₹10,30,000 in favor of the respondent bracket complainant in the trial court, by the order of upon met of the matter dated 19/7/2022, however, the entire amount was directed to be released by the trial court, when in fact is only the 50% of the amount, that is a sum of ₹5,15,000 was deposited in the trial court, and the another sum of ₹5,15,000 was deposited in the session judges court in the criminal appeal. 14/2019. Now through this memo for being spoken to is prayed to prayed for a direction for the release of the sum of 15 lakh, 5,15,000 deposited in the session judges court in criminal appeal 14/2019. Now through this memo for being spoken to, it is prayed that the release of the amount be ordered to both the trial court and the session judges court at ₹5,15,000 each. Next, a perusal of the compromise petition filed under section 147 of NI Act, based upon which the order dated 19/7/2022 came to be passed, shows that a sum of ₹5,15,000 each was deposited in the trial court and in session judges court. In the light of the above, the following order is passed. Next line. In modification of the order dated 19/7/2022 passed in this matter, out of the amount of ₹10,30,000 order to be released in favor of the respondent bracket in the trial court, comma, a sum of ₹5,15,000 is ordered to be released by the trial court Hesraki, and another sum of ₹5,15,000 be released in favor of the very same complaining, the same respondent here in bracket complainant in the trial court by the session judges court Hesraki, said to have been deposited in CC number 236/2016 and criminal appeal number 14/2019 respectively. This portion of this order would be considered as a part of the original order dated 19/7/2022. Yes.
Not press fellows.
Learned counsel for the applicant, public respondent in A2/22, first category. Submits that he could not press on A2/22. In view of the same, the A2/22 stands disposed as not pressed. Amal will invert heard on the being spoken. Yes, next.
Serial number 22, Sridhar K. Kishore Kumar as correspondent.
Who is for complaining? What was the check amount?
Check amount was 3,30,000.
You did file the case with respect to one check or two check?
Only one check.
What about the other check for 3.5 lakh?
That was honored. That check was honored.
That was honored.
Yes, sir.
What was dishonored was only 3,30,000.
Yes, sir.
ಅದ್ಯಾವ್ದು ಇಸ್ಕೊಳ್ಳಿ. ಇಸ್ಕೊಳ್ಳಿ. ಗೊತ್ತು. There are counsel from both sides, along with the parties from the both sides, as against them are physically present. Both sides have filed an application to IA 5 of 2022, section 147 of NIA. Permission to come for the matter and to acquit the petitioner of the alleged offence punishable under section 138 of Negotiable Instrument Act. The submission from both sides. This petitioner who is you identify him. ಏನಪ್ಪ ರಾಜಿ ಏನ್ ಮಾಡ್ಕೊಂಡಿದ್ರಿ? ಏನ್ ರಾಜಿ ಮಾಡ್ಕೊಂಡಿದ್ರಿ? ಕಾಂಪ್ರಮೈಸ್ ಏನು? ಏನ್ ಕಂಡೀಷನ್ ಏನು? ಉಳಿದಿರೋ ದುಡ್ಡು 87,500. You have compromised the matter. How much of amount you have agreed to receive from him? ಎಷ್ಟು ದುಡ್ಡು ಅವ್ರ ಹತ್ರ ತಗೊಳ್ಳಿಕ್ಕೆ ಒಪ್ಕೊಂಡಿದ್ದೀರಿ?
Can I translate it to Hindi? Because she knows Hindi.
So without knowing either English or particularly the local language, they are doing their avocation or business in Karnataka for such a long time. That is Bengaluru. ಅಲ್ವೇ? ಇಲ್ಲಿ ಕನ್ನಡ ಬಂದ್ಬಿಟ್ಟು ಉಳಿದಿದ್ದು ಯಾವ ಭಾಷೆ ಬಂದ್ರು ವ್ಯವಹಾರ ಮಾಡ್ಬೋದು, ಬದುಕಬಹುದು. ಕನ್ನಡ ಬಂದ್ರೆ ಕಷ್ಟ ಬದುಕೋದು. ಹೇಳಿ. Now, how much she is receiving now?
5,50,000 rupees. 87,500 is already deposited in the trial court, and the remaining amount is paid through the DD, and the remaining amount may be released from the trial court.
Who have said that remaining amount be released and in whose favor?
In the petition, it is mentioned.
Read that particular portion, please.
Petition already deposited. And for the trial court in compliance with all.
Yes. Is this sufficient?
Application for flowing.
She has agreed. Has he given his consent for the release? Has he stated his no objection for the release? If I say in the compromise term that say the respondent has agreed to withdraw that amount, do you think the trial court would release that amount to her? Yes. Tell your client where is the graded cost. He has to pay 49,500 rupees graded cost and the fine. Absolutely not. Admittedly, the land counsel for the petitioner who concedes that this court had brought to the notice of the parties on 14/11/2022 of the liability of the petitioner to pay the graded cost. However, the petitioner requires its accommodation to pay the graded cost. Yes, to enable for payment of the graded cost in accordance with law in the presence of the court, and also for the payment of the fine amount. A week's time as credit is granted. The matter is treated as part of list the matter immediately after a week. Yep.
Serial number 23, Sridhara K. Jairaj G for respondent.
ಅದೇನ್ ಇದೇ ಮ್ಯಾಟ್ರು ಐಎ ಅಂತಂದ್ರೆ ಐಎ ಕೊಡಲಿ ನಿಮ್ಮ ಪ್ಯಾಕಿಂಗ್ಗಳನ್ನು ಆಮೇಲೆ ಮಾಡಿ. The counsel from both sides present heard on IA5 or 22 filed an so in view of the statement made in this, for the reason shown in the affidavit accompanying the application, and also considering the fact that for the releasing of the amount in favor of the complainant, since the trial court records are required by the trial court, A5 or 22 is allowed in part, and trial court record are ordered to be returned to the said trial court without delay. However, with a request to the said trial court to return the records to this registry of this court within 4 weeks from today. Yes.
Serial number 24, Srinivas V. Satish Kumar HS for respondent.
Yes, please.
I have to deposit them. Order to pay on 26 of weeks. Whatever to arrange them, but to deposit before the banking comes. The former is not able to arrange it. Any condition may be imposed. Tomorrow will deposit the money, 50% of them.
Yes, please.
the report, madam.
Have taken NBW against him. Land counsel from both sides present. Or both sides on A2/22. Filed by the petitioner and sections also seeking extension of time to complete the terms of the interim order dated 26/2020. Considering the reasons shown there. Two bottom part with the cost of rupees 2,000 payable by the petitioner to the respondent in the form of. Are paying the cost right now or are you depositing it in the trial court?
Both of them. Yeah, actually, the course of the day.
Subject to the payment of the cost of rupees 2,000 payable by the petitioner to the respondent. Time of 2 weeks granted. Void order dated 26/2022 is extended. Period of 10 days from today. It's made clear that failing to comply the order, failing to comply the terms of the order dated 26/2022. Within the extended period of and by paying the cost would desensitize the petitioner when the benefit of the order dated 26/2022 and the extension granted today. Yes.
Serial number 25, SPP.
Special case number 2022. Forwarded to the
The submission of CG for the petition, there is the petition being put order. Issue emergency notice to the respondents, both on the main petition and on A1/22. Returnable vote. Okay. One.
Serial number 26, Badrinath R.
Emergency notice, both on petition and IAs. Format is in wrong format use material, those correct as the use.
Serial number 27, Murthy DL.
File with the state section 218 of CRPC. The same employment as the parties.
Why do you not file any revision? Whether the proposed case is so influential. What is the stage of the case now?
It's party exam.
How many witnesses have been examined?
CW 1 party.
For the submission of 11th council for the petition. The SCGP from advance copy has been served. Is also present. There is the included R. I am of the view that before proceeding to pass any order on IA1 and 2 of 2022, the respondents be notified. Accordingly, issue emergent notice to the respondent, both on the main petition and on IA1 and 2 of 2022. ನೀವು ಕೂಡ ನೋಟಿಸ್ನಲ್ಲಿ ನೀವು ಇದನ್ನು ಬಿಟ್ಟಿದ್ದೀರಿ ಐ ಆಮ್ ಆಫ್ ದ ವ್ಯೂ ಅನ್ನೋದು ಅಷ್ಟೇ ಮಾಡ್ತೀರಿ ಫಾರ್ಮೆಟ್ emergent notice on the respondents both on the main petition and on A1 and 2 of 2022. The CGP takes notice for respondent number 1. Petitioner to pay the necessary procedure office if not already done within a day from today to ensure this issuance of ensure the bid for issuance of emergent notice upon respondent number 2.
Admission matter. Serial number 32. Vidyasagar R. Manu Shankar SS correspondent.
Appeal not complied with the order means what order?
20% ಆರ್ಡರ್ ಮಾಡಿದ್ದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿರಲಿಲ್ಲ. ಸಸ್ಪೆನ್ಷನ್
Appeal ಅಲ್ಲಿ 20% ಕಟ್ಟಲಿಲ್ಲ ಅವರು. Then why did you not say the execute NBW if the term was not complied?
ರೆಕಾರ್ಡ್ ಆಗ್ಬಿಟ್ಟಿತ್ತು. ರೆಕಾರ್ಡ್ ಕಾಲ್ ಆಗಿದ್ದರಿಂದ
Counsel from both sides present. Both side on only 1/22. ಇದರದನ್ನೆಲ್ಲ ಫಾರ್ಮ್ಯಾಟ್ ಇಟ್ಕೊಡಿ. ಎರಡು both side ಅಂತ ಮಾತ್ರ 60% trial court. 1 lakh personal bond, 2 sureties, PCR, SCR.
Cell number 33, Vidyasagar. Manushankar, SS correspondent.
ಇದರಲ್ಲೂ ಅವ್ರು ಕಟ್ಟಲಿಲ್ವಾ? ಡೆಪಾಸಿಟ್ ಮಾಡಲಿಲ್ಲ. Including the deposit made if any ಅನ್ನೋದು ಬರಲ್ಲ. Number 33, same order.
Cell number 34, Vishwanath Shetty V.
NBW issue executed.
35% as the deposit before first of all.
50% 2 weeks trial court. 50,000 rupees, 2 sureties, emergent notice, processed during the day. PCR, SCR.
Cell number 35, Uday Kumar Ji.
There is NBW issue.
Yes, sir.
executed.
Process that.
Same order, 50%, 2 weeks, Rampur, 50,000 rupees, 2 sure rupees. Pay the process today, please.
Serial number 36, M. Ganesh.
$61,000 is already been deposited.
Deposit 50% of the fine amount after deducting what you have already deposited. Same order, 3 weeks. Pay the process today, please.
Serial number 37, Latif B. S50 served. Serial number 37, Latif B. SPP.
None appearing this matter, hence the matter could not be proceeded today. With this matter in the week after next, in earlier posting would be only after bringing today's observation to the notice. Yes.
Continuation argument, serial number 38, Shishal A. Hubli, HCGP correspondent.
None appear possible.
Serial number 39, TV Vijay Raghavan, Geeta Menon correspondent.
Any settlement?
My counsel is trying to, what you call, get in touch with him through the old sources of friends. Like
I couldn't get.
I contacted him on the phone, but he did not pick up the phone. And therefore, I conveyed this message to my client because he's in Bombay, the accused. So I said, through common friends, try and contact him and make sure that, he's conveyed this message that he should come to the court and see when the matter could be settled. But we have been able to get through him through the third parties, but he is still not not responding. Therefore, my clients are still pursuing it matter with him or trying to do that. But in the meantime, I suggest my lord, your lordship may refer this matter back to the sessions court. Let the matter be settled with merits, and if it is possible, let them get it done there. Because it may take time. I do not know how long it will take before your lordship for them to come here to court. As she has also tried, he has not been responding to her also.
When you continue your argument, we will hear your argument and
My only submission is this, my lord, I brought to your lordship's attention to para 21 of the appellate court judgment. In internal page 20. And wherein the court said that they are not going to examine or express any opinion on the merits and evidence of the case. Because it's being.
para 21 now.
Para 21 of the appellate court judgment. And internal page 20 of that. It may be that if the matter is remanded back, the parties may face inconvenience and hardship. Because already once trial is completed and judgment is rendered on the merits. In this regard, relying on the judgment of the Honorable High Court of Karnataka noted above, I note that the Honorable High Court of Karnataka is pleased to know these circumstances and laid down guidelines to pass necessary orders of the initial stage of the proceedings. Without expressing anything on merits regarding the alleged facts and circumstances involved in the case and the nature of evidence placed on record by the parties. As because the proceedings in this case within the trial court are void in nature, in the light of the principles of law laid down in the laws and disciplines, I am of the view that there is no course open but to remit the matter that for fresh trial by setting aside the impute judgment.
That's all. Also from both sides present, and it is submitted with the attempt to certain the possibility of settlement in the matter could not yield any positive result. In the light of the above. For the respondent argument. But for professional submission orders. Yes.
Fine, hearing matter, serial number 41. Vishwanath Pujari, SCG for respondent.
Yes, please.
605. 34. I took the accused. 19 years old, he had 2 days. Then 23 to 5 years. After the class returning. One minute in the mark the car and come there. And when you pull inside the car. At that time, other friends are asked to together into the car. In the end, other friends shouted at them. At that time, other classmates voice rushed to the spot and one hold of like A1 and A2 and took them inside the places of college along with the said car. And then they called the police, which came to the college premises and college authorities handed over the cases A1 and A2 to the police. Police took the A1 and A2 to the police station along with the car.
1 minute.
Exhibit B to Hajar and systems. Yes, please. Microphone set ಮಾಡಿ.
File appeal before fast track at Volunteers and fast track for conformity. Complaint is victim gave a complaint, returns complaint before the police station. Classified the police. Yes, that EW, my point of argument, my lord. When at the incident, other friends are with the together of the incident, they have not supported to the prosecution. When PW 127 valid at the court, they were not supported. Then other witnesses cannot be believed. There is only one point, madam.
How do you arrive at that hypothesis that when the friends of CW1 have not supported the case of prosecution, the other witnesses cannot be believed?
Because they are not at the spot. They are only the circumstances that they brought to these two accused in car inside the college premises. Then other witnesses are all for that respect.
Yes.
Another my point, my lord, when the incident is at 5 o'clock, at 5 p.m., in front of the gate. At that time, there were many people and huge gather of people. That the incident cannot be possible at that time because there were a lot of people there because it is in front of the gate. College gate.
Yes.
Another one point, my lord. That is not the case of recipient there. That these accused tried to escape from that spot. Because two other students got to hold of that students and we took them to the inside the premises.
Who did not try to escape?
Like A1 and 2, they were not trying to escape from this spot.
By that, what it can be for?
They were there, students, other students are got hold of that accused and we took them easily inside the premises of the college. A1 and A2 by the other students.
It is true. By that, what you want to infer? Accused number 1 and 2 were caught red-handedly. According to you, they did not try to escape from the spot.
It's because my God, there are people, gathering people are there, but they try to kidnap the girl.
They're trying to.
They never, it's not the case of the prosecution that they try to escape from this spot. It means there are so many people, they not have, not the case of escape.
May be true, but say by that, what can be inferred? Why you are telling that, say, by telling that, what do you want me to infer?
That not incident to not happen. Because there is the other people and all gather of people.
That is said, there were a lot of people gathered near the gate, therefore, the incident couldn't have happened.
Prior to that, madam, prior to incident, not incited, when at the moment of the shouted the girl and others, then other students rushed to the spot.
Yes, please.
And Renuka, victim. Evidence of identification of one victim, Renuka.
SHP ಕೂತ್ಕೊಳ್ಳಿ.
ಆರೋಪಿಗಳು ನಾನು 2008 ಸಾಲಿನ PCMC ವ್ಯಾಪಾರ ದಿನಾಂಕ 23/12/2008 ಮಂಗಳವಾರ ಸಾಯಂಕಾಲ 5 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ನಾನು ತರಬೇತಿ ಮುಗಿಸಿಕೊಂಡು ಮನೆಗೆ ಹೋಗುತ್ತಿದ್ದೆವು. ನನ್ನ ಜೊತೆ ನನ್ನ ಗೆಳೆಯರಾದ ದಾಸ 2 ರಿಂದ 5ರವರು ಇದ್ದರು. ಆ ರೀತಿ ಹೋಗುತ್ತಿದ್ದಾಗ ಒಂದು ಹಿರಿಯ ಕಾರು ಬಂದು ಅದರ ಚಾಲಕ ಇದಾಗಿತ್ತು. ಕಾರು ಒಳಗಡೆ ಮತ್ತೊಬ್ಬ ವ್ಯಕ್ತಿ ಕುಳಿತಿದ್ದರು. ಆತನ ಹೆಸರು ಗೊತ್ತಿಲ್ಲ. ಲಿಂಗರಾಜ್ ಎನ್ನುವ ವ್ಯಕ್ತಿ ಕಾರನ್ನು ನಿಲ್ಲಿಸಿ ಬಾಗಿಲು ತೆಗೆದು ನನ್ನನ್ನು ಒಳಗೆ ಬೆದರಿಸಲು ಪ್ರಯತ್ನ ಪಟ್ಟರು. ನಾನು ತಕ್ಷಣ ಜೋರಾಗಿ ತಿರುಗಿಕೊಂಡೆ. ಆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಸ್ನೇಹಿತರಾದ ಚೆನ್ನಯ್ಯ, ಲೋಕೇಶ, ಕಾಂತರಾಜ್ ಮತ್ತು ಇತರರು ಓಡಿ ಬಂದರು. ಆ ಸಮಯದಲ್ಲಿ ಆರೋಪಿಗಳೆಲ್ಲರೂ ಬಲವಂತವಾಗಿ ಕಾರಿನ ಒಳಕ್ಕೆ ಹೋಗುತ್ತಿದ್ದರು. ಅಷ್ಟರಲ್ಲಿ ನಮ್ಮ ಕಾಲೇಜಿನ ಪ್ರಾಂಶುಪಾಲರ ದತ್ತಾತ್ರೇಯರು, ಕಾರ್ಯದರ್ಶಿ ಶಂಭುಲಿಂಗಪ್ಪನವರು, ಹಳ್ಳಿಮೈಸೂರಿನ ಬಸವರಾಜು ಎನ್ನುವವರು, ಉಪನ್ಯಾಸಕರಾದ ವೀರೇಂದ್ರ ಹಾಗೂ ಬಾಬು ಎನ್ನುವರು ಜೊತೆಗೆ ಬಂದು ನಮ್ಮನ್ನು ಹಾಗೂ ಕಾರನ್ನು ಮತ್ತು ಆರೋಪಿಗಳನ್ನು ಕಾಲೇಜ್ ಹತ್ತಿರ ಕರೆದುಕೊಂಡು ಹೋದರು. ಸದರಿ ಕಾರಿನ ಸಂಖ್ಯೆ ಏನಾಗುತ್ತೆ, ಅದು ಆಗಿರುತ್ತದೆ. ನನ್ನ ಕೈಯನ್ನು ಹಿಡಿದು ತೆಗೆದುಕೊಳ್ಳಲು ಪ್ರಯತ್ನ ಪಟ್ಟವರ ಹೆಸರು ನಿಂಗೇಗೌಡರ ಮಗ ಕೀರ್ತಿಯಾಗಿದ್ದು 1ನೇ ಆರೋಪಿಯಾಗಿರುತ್ತಾರೆ. ಕಾರಿನ ಚಾಲಕ ಬಸಪ್ಪನ ಮಗ ನಿಂಗೇರಾಜು ಆಗಿದ್ದು 2ನೇ ಆರೋಪಿಯಾಗಿರುತ್ತಾರೆ. ಇಬ್ಬರನ್ನು ಹೊರನಡೆಸುತ್ತಿರುವ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಕರೆದುಕೊಂಡು ಪೊಲೀಸರು ನನ್ನನ್ನು ಪ್ರಯತ್ನ ಪಟ್ಟಿರುತ್ತಾರೆ. ಪೊಲೀಸರು ನನ್ನಿಂದ ಹೇಳಿಕೆ ಬರೆದುಕೊಂಡು ನಾನು ದೂರು ಕೊಟ್ಟಿದ್ದೇನೆ. ಸಾಕ್ಷಿದಾರರನ್ನು ಗುರುತಿಸಿದ್ದು ದೂರನ್ನು ನಿಚಾಣಿಸಲಾಗಿದೆ. ಪೊಲೀಸರು ಕಾರನ್ನು ಮತ್ತು ಆರೋಪಿಗಳನ್ನು ತಮ್ಮ ವಶಕ್ಕೆ ತೆಗೆದುಕೊಂಡು ನನ್ನನ್ನು ವೈದ್ಯರ ಹತ್ತಿರ ಕರೆಸಿಕೊಟ್ಟರು. ರಾತ್ರಿ 9 ಗಂಟೆಯಿಂದ 10 ಗಂಟೆಯವರೆಗೆ ಒಂದು ನನ್ನ ಸಹಿಯನ್ನು ಸೂಚಿಸುತ್ತಾರೆ. ಪ್ರಕೃತಿ ಮಾರ್ಗಗಳನ್ನು ನಿಶಾನಕ್ಕೆ ಬೆರಳುವಂತರು ಸಂಖ್ಯೆಯನ್ನು ನಿಶಾನಕ್ಕೆ ತಿಳಿಸಲಾಗಿದೆ. ನನ್ನ ಜೊತೆ ಬಸವರಾಜ್ ಮತ್ತು ನಾಗರಾಜ್ ಕೂಡ ಸಹಿ ಮಾಡಿದ್ದಾರೆ. ಮೇಲೆ ಹೇಳಿದ ಇತರೆ ಸಂಖ್ಯೆಯ ವಾಹನವನ್ನು ಪೊಲೀಸರು ಅಮಾನತು ಪಡಿಸಿಕೊಂಡರು. ಮಾರನೇ ದಿನ ಪೊಲೀಸರು ಹೊರಕ್ಕೆ ಬಂದು ಮಾದರಿ ಅಲ್ಲಿ ನಾನು ಕೂಡ ಹಾಜರಿದ್ದು ಇದು ಮಾಡಿದ್ದೇನೆ. ಸಾಕ್ಷಿ ಸಲಮಾದರ್ ನೋಡಿ ಗುರುತಿಸಿದ್ದಾರೆ. ಅದು ನಿಶಾನಕ್ಕೆ 3 ಸಾಕ್ಷಿಯವರ ವಿರುದ್ಧವನ್ನು ನಿಶಾನಕ್ಕೆ 3A ಎಂದು ಗುರುತಿಸಲಾಗಿದೆ. ಸಲಮಾದರನ್ನು ಅಲ್ಲಿ ಮೈಸೂರಿನಲ್ಲಿ ಬರೆದಿರ್ತಾರೆ. ಅಲ್ಲಿ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಇರುತ್ತದೆ. ಸದರಿ ಮಾದರಿಗೆ ನಾನು ಬಸವರಾಜ್ ಕಾರೇಗೌಡ ಅನ್ನುವರು ಸಹಿ ಮಾಡಿದ್ದಾರೆ. ಅದರ ಬಳಿಕ 10 ರಿಂದ 11 ಗಂಟೆ ಸಮಯವಾಗಿತ್ತು. ಸಾಕ್ಷಿ ಅಮಾನತು ಮಾದರ್ ನೋಡಿ ತಮ್ಮ ಸಹಿ ಗುರುತಿಸಿದ್ದಾರೆ. ಸದರಿ ಮಾದರನ್ನು ನಿಶಾನಕ್ಕೆ 4 ಎಂದು ಸಾಕ್ಷಿಯ ಸಹಿಯನ್ನು ನಿಶಾನಕ್ಕೆ 4A ಎಂದು ಗುರುತಿಸಲಾಯಿತು. 23/12/2008 ಈ ಮಾದರಿ ಬರೆದಿರುತ್ತಾರೆ. ಇದನ್ನು ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆಯಿಂದ 12 ಬರೆದಿರುತ್ತಾರೆ. ಈ ಸಮಯದಲ್ಲಿ ಎಂಬ ವಾಹನವನ್ನು ಅಮಾನತು ಮಾಡಿಕೊಂಡರು. ಕೇಸ್ ನಂಬರ್ ಸದರಿ ಮಾದರಿಗೆ ನಾಗರಾಜ ಬಸವರಾಜು ಹಾಗೂ ನಾನು ಸಹಿ ಮಾಡಿದ್ದೇನೆ. ಆ ದಿನ ಅಮಾನತು ಮಾಡಿಕೊಂಡ ವಾಹನ ಈಗಿನ ಕೋರ್ಟಿನ ಮುಂದೆ ಇರುತ್ತದೆ. ಅದನ್ನು ಮುದ್ದೆ ಮಾಡುವುದು ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಪಾಟಿಸಬಹುದು. ಆರೋಪಿತರು ನನಗೆ ಯಾವತ್ತೂ ಪರಿಚಯವಿಲ್ಲ. ಆರೋಪಿತರು ಯಾವ ಊರಿನವರಂತ ಮೊದಲು ನನಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ. ದೂರು ಕೊಟ್ಟ ಮೇಲೆ ಗೊತ್ತಾಗಿದೆ. ಆರೋಪಿತರು ಇಂತಹ ಊರಿನವರು ಅಂತ ನನಗೆ ಯಾರೂ ಹೇಳಿಲ್ಲ. ದೂರನ್ನು ನಾನೇ ಬರೆದೆ. ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ದೂರನ್ನು ಬರೆದೆ. ಸಂಜೆ 7:15 ಗಂಟೆಗೆ ನಾನು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಬಂದೆ. ನಾನು ಸೀದಾ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋದೆ. ಪೊಲೀಸರಿಗೆ ನಾನು ಸೆಕ್ರೆಟರಿ ಮತ್ತು ಪ್ರಿನ್ಸಿಪಾಲ್ ವಿಷಯವನ್ನು ತಿಳಿಸಿದೆವು. ನಾನು ಹೇಳಿದಂತೆ ವಿಷಯವನ್ನೆಲ್ಲ ಪೊಲೀಸರು ನೋಟ್ ಮಾಡಿಕೊಂಡರು. ಪೊಲೀಸರು ಬರೆದ ಮೇಲೆ ನನ್ನನ್ನು ಸೆಕ್ರೆಟರಿಯವರನ್ನು ಮತ್ತು ಪ್ರೆಸಿಡೆಂಟ್ ಅವರಿಂದ ರುಜು ಮಾಡಿಕೊಂಡರು ಎನ್ನುವುದು ಸರಿ. ಪೊಲೀಸರು ವಿಚಾರಣೆ ಮಾಡಿ ಊರಿನವರು ಅಂತ ಹೇಳಿದ್ದರಿಂದ ನಾನು ಅವರ ಹೆಸರು ಮತ್ತು ಊರನ್ನು ಬರೆದೆ. ನನ್ನ ಸೆಕ್ರೆಟರಿಯವರ ಮತ್ತು ಪ್ರಿನ್ಸಿಪಾಲ್ ಹೇಳಿಕೆಯಲ್ಲಿ ಆರೋಪಿತರ ಹೆಸರು ಮತ್ತು ವಿವರವನ್ನು ಹೇಳಿದೆ. ನನ್ನ ಸೆಕ್ರೆಟರಿಯವರನ್ನು ಮತ್ತು ಪ್ರಿನ್ಸಿಪಾಲರನ್ನು ಇದೇ ರೀತಿ ಬರೆದುಕೊಡು ಅಂತ ಪೊಲೀಸರು ಹೇಳಿದ್ದರಿಂದ ನಾವು ಹೇಳಿಕೊಳ್ಳುತ್ತೇವೆ ಎನ್ನುವುದು ಸುಳ್ಳು. ನಡೆದ ಘಟನೆಯ ಬಗ್ಗೆ ಮಾತ್ರ ಬರೆದಿದ್ದೆ. ಆರೋಪಿತರ ವಿವರವನ್ನು ನಾನು ದೂರು ಕೊಡುವ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ಶಿಕ್ಷಕರು ಹೇಳಿದರು. ನಮ್ಮ ಕಾರ್ಯದರ್ಶಿ ಅವರಿಗೆ ಸೇರಿದ ಕಾರ್ಯದಲ್ಲಿ ನಾನು ನನ್ನ ಸ್ನೇಹಿತರು ಕಾರ್ಯದರ್ಶಿ ಮತ್ತು ಉಪನ್ಯಾಸಕರು ವೀರೇಂದ್ರ ಅಲ್ಲಿ ಮೈಸೂರಿನಿಂದ ಹೊರನಡೆದುಕೊಳ್ಳಲು ಬಂದರು. ಆ ಕಾರಿನ ನಂಬರ್ ನನಗೆ ಗೊತ್ತಿತ್ತು. ನಾನು ಬಂದ ಕಾರು ಟಾಟಾ ಸುಮಾರು ಇತ್ತು. ಸದರಿ ಕಾರು ಸಂಜೆ ಸುಮಾರು 7:30 ಗಂಟೆಗೆ ಹಸಿ ಮೈಸೂರನ್ನು ಬಿಟ್ಟಿರಬಹುದು. 20 ನಿಮಿಷಗಳ ಬಂದೆವು. ರಾತ್ರಿ 8:30 ಗಂಟೆ ದೂರನ್ನು ಬರೆದುಕೊಟ್ಟು ನಾನು ದೂರು ಕೊಡುವ ಸಮಯದಲ್ಲಿ ಕಾರ್ಯದರ್ಶಿಗಳಾದ ಸಂಬುಲಿಂಗಪ್ಪ ಪರೀಕ್ಷೆಗಾಗಿ ಕಳುಹಿಸಿಕೊಟ್ಟರು. ಆಸ್ಪತ್ರೆಗೆ ಹೋದಾಗ ರಾತ್ರಿ 9 ಗಂಟೆ ಆಗಿರಬಹುದು. ನನಗೆ ರಕ್ತ ಬರುತ್ತಿದ್ದ ಗಾಯಗಳು ಆಗಿರಲಿಲ್ಲ. ನನ್ನ ಬಲಗೈಯನ್ನು ಹಿಂದಕ್ಕೆ ಎಳೆದು ತಿರುಗಿದ್ದರಿಂದ ನನ್ನ ಬಲ ಭುಜ ನೋವಾಗಿದೆ. ನನ್ನ ಬೆನ್ನಿಗೆ ಇಡಿ ಮಾಡಿ ಬಿದ್ದಿದ್ದರು. ಆ ಭಾಗದಲ್ಲಿ ಬೆರಳು ಮೂಡಿದ್ದೆ ಎಂಬ ಸವಾಲಿಗೆ ಸಾಕ್ಷಿ ಮುಷ್ಟಿಯಿಂದ ಬಿದ್ದಿದ್ದು ಊದಿಕೊಂಡಿತ್ತು ಎನ್ನುತ್ತಾರೆ. ಬೆನ್ನಿನ ಬಲಭಾಗದ ಭುಜದ ಹಿಂಭಾಗಕ್ಕೆ ಬಿದ್ದಿದ್ದರು. ನನ್ನ ಬಲ ಮುಂಗೈನ ಹಿಂಭಾಗದಲ್ಲಿ ಅಂದರೆ ಕೀಲಿನ ಕೆಳ ಭಾಗದಲ್ಲಿ ನೋವಾಗಿದೆ. ವೈದ್ಯರ ಪರೀಕ್ಷಿಸಿದವರು ಪುನಃ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋದೆ. 10 ನಿಮಿಷಕ್ಕೆ ವೈದ್ಯರ ಬಳಿ ಕುಳಿತುಕೊಂಡು ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋದೆವು. ಆಸ್ಪತ್ರೆಗೆ ಹೋಗುವುದಕ್ಕೆ ಮೊದಲೇ ದೂರನ್ನು ಕೊಡಲಾಗಿದೆ. ಆಸ್ಪತ್ರೆಯಿಂದ ಬಂದ ಮೇಲೆ ಹಳ್ಳಿ ಮೈಸೂರಿಗೆ ಹೋದೆವು. ಆಸ್ಪತ್ರೆಯಿಂದ ಬಂದ ಮೇಲೆ ಪುನಃ ಹೇಳಿಕೆಯನ್ನು ಬರೆದುಕೊಳ್ಳಲಿಲ್ಲ. 24ನೇ ತಾರೀಕು ಸಂಜೆ ಕೋಣನೂರಿಗೆ ಹೋದೆವು. ಕೋಣನೂರಿಗೆ ನಾನು ಮತ್ತು ನನ್ನ ತಾಯಿ ಹೋದೆವು. ನನ್ನ ಊರಿನಲ್ಲಿ ಆರೋಪಿತರು ಯಾವ ಹಳ್ಳಿ ಮತ್ತು ತಾಲೂಕಿಗೆ ಸೇರಿದವರು ಅಂತ ಹೇಳಿದ್ದೇನೆ. ಇಬ್ಬರ ಬಗ್ಗೆಯೂ ಹೇಳಿದ್ದೇನೆ. ನನ್ನ ತಾಯಿಯ ಹೆಸರು ಆರಬರು. ನಾವು ಅಡಿವಾಳ ನಗರಕ್ಕೆ ಸೇರಿದವರು. ಅಪ್ಪೂರಿನ ಪಕ್ಕಮ್ಮ ನನಗೆ ಗೊತ್ತು. ಹಾಗೆ ನಮ್ಮ ಜನಾಂಗಕ್ಕೆ ಸೇರಿದ್ದ ಅವರು ನಮ್ಮ ಸಂಬಂಧಿಕರು. ನನ್ನ ಕಟ್ಟಿಗೆ ಸೇರಿಸಲು ಪಕ್ಕಮ್ಮಳ ಸೋದರ ಮಕ್ಕಳ ಮೂಲಕ ಸಹಕರಿಸಿದ್ದರಿಂದ ಆಕೆ ನಮ್ಮ ಮನೆಗೆ ಹೋಗಿ ಬಂದು ಪರಿಚಯಿಸಲಾಗಿದ್ದರು. ನನ್ನನ್ನು ಬಲಾತ್ಕಾರವಾಗಿ ಅಪಹರಿಸಬೇಕು ಅಂತ ಆರೋಪಿಸಲು ಪ್ರಯತ್ನ ಪಟ್ಟಿಲ್ಲ ಎನ್ನುವುದು ಸುಳ್ಳು. ನನ್ನ ತಾಯಿ ಮತ್ತು ಪದ್ಮಮ್ಮ ನನಗೂ ಪರಿಚಯಿಸಿ ಪದ್ಮಮ್ಮ ಮತ್ತು ಶಾರದಮ್ಮನ ನಡುವೆ ನಡೆದ ಒಂದು ಘಟನೆಯ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪದ್ಮಮ್ಮ ಮತ್ತು ಆರೋಪಿಗಳನ್ನು ಶಿಕ್ಷಿಸಬೇಕು ಅಂತ ನಾನು ಸುಳ್ಳು ಫಿರ್ಯಾದು ಕೊಟ್ಟಿದ್ದೇನೆ ಎನ್ನುವುದು ಸುಳ್ಳು. ಪೊಲೀಸರು ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಕಾರನ್ನು ನನಗೆ ತೋರಿಸಿ ನನ್ನನ್ನು ಅಪಹರಣ ಮಾಡಲು ಉಪಯೋಗಿಸಿದ ಕಾರು ಇದೆಯಾ ಅಂತ ಹೇಳಿದಾಗ ಅದೇ ಕಾರು ಅಂತ ಗುರುತಿಸಿ ಆಗ ಆ ಕಾರಿನ ನಂಬರನ್ನು ತಿಳಿದುಕೊಂಡೆ. ನನ್ನನ್ನು ಅಪಹರಿಸುವ ಕಾಲದಲ್ಲಿ ಆ ಕಾರಿನ ನಂಬರ್ ನನಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ. ಸುಮಲತಾ, ಶಿವಮ್ಮ, ಪವಿತ್ರ ಎಲ್ಲರೂ ಕೂಡ ನನ್ನ ಜೊತೆಯಲ್ಲಿ ಓದುತ್ತಿದ್ದರು. ನಮಗೂ ಅವರಿಗೂ ಯಾವುದೇ ದ್ವೇಷವಿಲ್ಲ. ನಮ್ಮ ಕಾಲೇಜಿನಿಂದ ಸುಮಾರು 100 ಮೀಟರ್ ದೂರದಲ್ಲಿ ಈ ಘಟನೆ ನಡೆಯಿತು. ಹೊರಗಡೆ ರಸ್ತೆಯ 2 ಕಡೆಗಳಲ್ಲಿ ಬೇಕಾದಷ್ಟು ಮನೆಗಳಿವೆ ಎಂದು ನಾನು ಹೇಳುವ ಸಮಯದಲ್ಲಿ ಹಳ್ಳಿಯಿಂದ ಹಿರಿಯೂರು, ಮೂಡಲ, ಮಾಯಗನಹಳ್ಳಿ, ಈ ಮಾಯಗನಹಳ್ಳಿ, ದಾಸನಹಳ್ಳಿ, ಕೊಪ್ಪಳು ಇತ್ಯಾದಿ ಗ್ರಾಮಗಳಿಗೆ ಹೋಗುವ ಜನರು ಬಹಳಷ್ಟು ಓಡಾಡುತ್ತಾರೆ ಎಂಬ ಸವಾಲಿಗೆ ಸಾಕ್ಷಿ ಆ ಸಮಯದಲ್ಲಿ ಯಾರು ಓಡಾಡುತ್ತಿರಲಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾರೆ. ಈ ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳದಲ್ಲಿ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಇರುತ್ತದೆ ಎನ್ನುವುದು ಸರಿ. ಪದವಿ ಕಾಲೇಜಿನಿಂದ ಹುಡುಗರು ನಾನು ಹೇಳುವ ಸಮಯದಲ್ಲಿ ಕಾಲೇಜು ಬರುತ್ತಿದ್ದಾರೆ ಎನ್ನುವುದು ಸುಳ್ಳು. ನಾನು ಕಾರಿನ ಒಳಗೆ ಹೋಗಿರಲಿಲ್ಲ. ನನ್ನನ್ನು ಕೈಯನ್ನು ಹಿಡಿದುಕೊಂಡು ಆರೋಪಿಗಳು ನನ್ನನ್ನು ಕಾರಿನ ಒಳಗೆ ಎಳೆದೂ ಇಲ್ಲ ಮತ್ತು ನನ್ನನ್ನು ಹಿಡಿದು ಹೋಗಲೂ ಇಲ್ಲ ಎನ್ನುವುದು ಸುಳ್ಳು. ನಾನು ಮತ್ತು ನನ್ನ ಸ್ನೇಹಿತೆಯರು ಒಬ್ಬರಿಗೊಬ್ಬರು ಮಾತನಾಡಿಕೊಂಡು ನಡೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದೆವು. ನಾನು ಹಳ್ಳಿ ಮೈಸೂರಿನಲ್ಲಿ ರೂಮಿನಲ್ಲಿ ವಾಸವಾಗಿದ್ದೆ ಎನ್ನುವುದು ಸರಿ. ನಮ್ಮ ಮುಂದೆ ಬಹಳಷ್ಟು ಜನರು ಹೋಗುತ್ತಿದ್ದರು. ಎಷ್ಟು ಜನರು ಹೋಗುತ್ತಿದ್ದರು ಅಂತ ನನಗೆ ನಿಖರವಾಗಿ ಹೇಳಲು ಆಗುತ್ತಿಲ್ಲ. ಪ್ರಿನ್ಸಿಪಾಲ್ ಮತ್ತು ಸೆಕ್ರೆಟರಿಗಳು 20 ನಿಮಿಷಗಳ ನಂತರ ಅಲ್ಲಿಗೆ ಬಂದರು. ಕಾಲೇಜು ಹತ್ತಿರಕ್ಕೆ ಪೊಲೀಸರು ಬಂದರು. ಸಬ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಬರಲಿಲ್ಲ. ಹೆಡ್ಮಾಸ್ಟರ್ಗಳು ಬಂದಿದ್ದರು. ಪೊಲೀಸರು ನಮ್ಮನ್ನು ಕೇಳಿಕೊಂಡರು. ಕಾಲೇಜಿನ ಹತ್ತಿರ ಪೊಲೀಸರು ಯಾವುದೇ ಮಾದರಿಗೆ ಬರವಣಿಗೆ ಮಾಡಿಕೊಳ್ಳಲಿಲ್ಲ. ಪೊಲೀಸ್ ಜೀಪಿನಲ್ಲಿ ನನ್ನನ್ನು ಅಪಹರಿಸಲು ಪ್ರಯತ್ನ ಪಟ್ಟವರನ್ನು ಪೊಲೀಸರು ಕರೆದುಕೊಂಡು ಬಂದರು. ಪೊಲೀಸರು ಆರೋಪಿಯನ್ನು ವಶಕ್ಕೆ ತೆಗೆದುಕೊಂಡರು. ಆರೋಪಿತರು ದುಷ್ಕೃತ್ಯವನ್ನು ಮಾಡಲಿದ್ದರೂ ನಾನು ಸುಳ್ಳು ಫಿರ್ಯಾದಿಯನ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ ಎನ್ನುವುದು ಸುಳ್ಳು. ನನ್ನನ್ನು ಅಪಹರಣ ಮಾಡಲು ಪ್ರಯತ್ನ ಸ್ಥಳದಲ್ಲಿ ಆದರೂ ಬರೆದುಕೊಂಡರು. ಬೆಳಿಗ್ಗೆ 10ರಿಂದ 11 ಗಂಟೆ ಸಮಯವಾಗಿತ್ತು. ಪ್ರಗತಿ ಮಾದರಿ ಮತ್ತು ದೂರು ಕೊಟ್ಟಾಗಲೂ ಕೂಡ ನಾನು ಮಾಡಿದ್ದೇನೆ. ಮಾದರಿಗೆ ಒಳನಡೆಸಿ ಕೂಡ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನನ್ನ ಪಡೆದಿದ್ದಾರೆ ಎನ್ನುವುದು ಸಂಜೆ ಕಾಲೇಜು ಬಿಟ್ಟ ಮೇಲೆ ನನ್ನ ತಂದೆ ತಾಯಿಗಳು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋದರು.
Yes, sir.
Other witnesses made up. 2 to 7 were classmates of the victim Renuka. But they all are not supported in the case of this prosecution, but accepting PW6 is opposed. PW6. Me, PW2 member. She is a classmate along with him according to the petition. She was with her at the time of incident. ಯೂನಿವರ್ಸಿಟಿ ವಿದ್ಯಾಲಯದಲ್ಲಿ ನಾನು ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿದ್ದೆ. 2006 ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆರೋಪಿಸಲು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಒಂದನೇ ಸಾರಿ ಹೇಗುತ್ತ ನನಗೆ ಗೊತ್ತು. ಆಕೆ ನನ್ನ ಜೊತೆಯಲ್ಲಿ ಸಹಪಾಠಿಯಾಗಿ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡುತ್ತಿದ್ದರು. ಯುವ ಮಾಧ್ಯಮದ ಚಂದ್ರಯ್ಯ, ಕಾಂತರಾಜ, ಯೋಗೇಶ ಇವರುಗಳು ನಮ್ಮ ಜೊತೆಯಲ್ಲಿ ಓದುತ್ತಿದ್ದರು. ಪ್ರಸಾದ್ ಎಂಬುವರು ನಮ್ಮ ವಿದ್ಯಾಲಯದ ಪ್ರಿನ್ಸಿಪಾಲ್ ಅವರಾಗಿದ್ದರು. ಕಂಬುಲಿಂಗಪ್ಪ ಎಂಬುವರು ನಮ್ಮ ಕಾಲೇಜಿನ ಕಾರ್ಯದರ್ಶಿಗಳು. ಬಾಬು ವೀರೇಂದ್ರ ಶಾರದಾ ಇವರೆಲ್ಲರೂ ನಮ್ಮ ಉಪನ್ಯಾಸಕರಾಗಿದ್ದರು. ಕಾಳಿಂಗ ಶೆಟ್ಟಿ ಮತ್ತು ಬಸವರಾಜ ನಮ್ಮ ಕಾಲೇಜಿನ ಹುಮ್ಮಸ್ಸರಾಗಿದ್ದರು. ಈ ಕೇಸಿನ ಬಗ್ಗೆ ಆರೋಪಿತರು ಏನು ಮಾಡಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಓದುವಾಗ ಆರೋಪಿತರು ಗಲಾಟೆ ಮಾಡಿದ್ದ ವಿಚಾರ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಒಂದು ವರ್ಷದ ಹಿಂದೆ ಕಾಲೇಜಿನಲ್ಲಿ ರೇಣುಗಳನ್ನು ಯಾರೋ ಕಾಲೇಜಿನ ಹುಡುಗರು ಅಪಹರಣ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದರು ಅಂತ ನನಗೆ ತಿಳಿಯಿತು. ಯಾವ ರೀತಿ ಅಪಹರಣ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನಾನು ಪೊಲೀಸರಿಗೆ ದಿನಾಂಕ 23/12/2023 ನಾನು ಹೇಳಿಕೊಡುತ್ತೇನೆ. ಸದರಿ ಹೇಳಿಕೆಯನ್ನು ಅಭಿವೃದ್ಧಿ ಈಶಾನ್ಯ 5 ನನಗೆ ರೇಣುಗಳನ್ನು ಆರೋಪಿತರು ಪರಿಚಯಿಸಿಕೊಂಡು ಹೋಗಲು ಪ್ರಯತ್ನ ಪಟ್ಟ ವಿಚಾರವನ್ನು ಅಪಹರಿಸಿಕೊಂಡು ಹೋಗಲು ಪ್ರಯತ್ನಿಸುವ ವಿಚಾರವನ್ನು ನಾನು ನಡೆಸಿದ್ದು ಎಲ್ಲರೂ ತಿಳಿಸಿದ್ದರೂ ಕೂಡ ಆರೋಪಿತರಿಗೆ ಹೆದರಿ ಮತ್ತು ಅವರಿಗೆ ಸಹಾಯ ಮಾಡಲು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಸರಿಯಲ್ಲ. PWC has the same witness. And the question is the same as per PW1. Sure. PW3.
Yes.
ಮೈಸೂರಿನಲ್ಲಿ ಇರುವ ಭಾರತ ವಿದ್ಯಾಲಯದಲ್ಲಿ ನಾನು BS ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿದ್ದೆ. 2006 ವೇಳೆಗೆ ಅಲ್ಲಿ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿದ್ದೆ. ನ್ಯಾಯಾಲಯದ ಮುಂದಿನ ಆರೋಪಿಗಳು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಒಂದನೇ ಸಾಕ್ಷಿ ನೇಮಕ ನನಗೆ ಗೊತ್ತು. ಆಕೆ ನನ್ನ ಜೊತೆಯಲ್ಲಿ ಸಹಪಾಠಿಯಾಗಿ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡುತ್ತಿದ್ದರು. ನಾನು ಸುಮಲತಾ, ಪವಿತ್ರ, ಚಂದ್ರಯ್ಯ, ಕಾಂತರಾಜು, ಯೋಗೇಶ ಇವರುಗಳು ನಮ್ಮ ಜೊತೆಯಲ್ಲಿ ಓದುತ್ತಿದ್ದರು. ದತ್ತಾತ್ರಿ ಎಂಬುವರು ನಮ್ಮ ವಿದ್ಯಾಲಯದ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ದರು. ಕಂಬುಲಿಂಗಪ್ಪ ಎಂಬುವರು ನಮ್ಮ ಕಾಲೇಜಿನ ಕಾರ್ಯದರ್ಶಿಗಳು. ಬಾಬು, ವೀರೇಂದ್ರ, ಶಾರದಾ ಇವರಿಬ್ಬರು ನಮ್ಮ ಉಪನ್ಯಾಸಕರಾಗಿದ್ದರು. ಕಾಳಿಂಗ ಶೆಟ್ಟಿ ಮತ್ತು ಬಸವರಾಜ ನಮ್ಮ ಕಾಲೇಜಿನ ಹುಮ್ಮಸ್ಸರಾಗಿದ್ದರು. ಕೇಸ ಬಗ್ಗೆ ಆರೋಪಿತರು ಏನು ಮಾಡಿದ್ದಾರೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಓದುವಾಗ ಆರೋಪಿತರು ಗಲಾಟೆ ಮಾಡಿದ್ದ ವಿಚಾರ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಹೀಗೆ 1 ವರ್ಷದಿಂದ ಕಾಲೇಜಿನಲ್ಲಿ ರೇಣುಗಳನ್ನು ಯಾರೋ ಕಾಲೇಜಿಗೆ ಅಪಹರಣ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದರು ಅಂತ ನನಗೆ ತಿಳಿಯಿತು. ಯಾವ ರೀತಿ ಅಪಹರಣ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದರು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆ ಪೊಲೀಸರು ದಿನಾಂಕ 23/2/2008 ಇದ್ದರು ಎಂದು ಹೇಳಿಕೆ ನೀಡಿದ್ದೇನೆ ಅಂತ ನಾನು ಪೊಲೀಸರ ಮುಂದೆ ಹೇಳಿಕೆ ಕೊಡುತ್ತೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸಭೆಯಲ್ಲಿ ಹೇಳಿಕೆಯನ್ನು ಅಭಿವೃದ್ಧಿ ನಿಶಾನೆ ನನಗೆ ರೇಣುಗಳನ್ನು ಆರೋಪಿಸಲು ಅಪಹರಿಸಲು ಪ್ರಯತ್ನ ಪಟ್ಟ ವಿಚಾರವನ್ನು ನಾನು ಹೆಚ್ಚಾಗಿ ಖಂಡಿಸಿ ಎಲ್ಲವೂ ತಿಳಿದಿದ್ದರೂ ಕೂಡ ಆರೋಪಿತರಿಗೆ ಹೆದರಿ ಮತ್ತು ಅವರಿಗೆ ಸಹಾಯ ಮಾಡಲು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ ಎನ್ನುವುದರೆ ಸರಿಯಲ್ಲ. PW 3/5 that's the same sentence, my lord.
Yes.
Then I read my Chandra, he supported this Chandra. PW 6, my lord. And it's also he was around with this victim at the time and 6. 2008ನೇ ಸಾಲಿನಲ್ಲಿ ಭಾರತ್ CH ಕಾಲೇಜಿನಲ್ಲಿ ನಾನು 2ನೇ ವರ್ಷದ ಡಿಗ್ರಿ ಓದುತ್ತಿದ್ದೆ. 12/12/2008 ಕಾಲೇಜಿಗೆ ಹೋಗಿದ್ದೆ. ರುಕ್ಮಿಣಿ, ರೇಣುಕಾ, ಸುಮಲತಾ, ಪವಿತ್ರ ಇವರೆಲ್ಲರೂ ನನ್ನ ಜೊತೆಯಲ್ಲಿ ಸಹಪಾಠಿಗಳಾಗಿದ್ದರು. ದಿನಾಂಕ 23/12/2008 5 ಗಂಟೆ ಕಾಲೇಜು ಮುಗಿಸಿಕೊಂಡು ಬಸ್ಸಿಗೆ ಹೋಗೋಣ ಅಂತ ಹಳ್ಳಿ ಮೈಸೂರಿನ ಬಸ್ ನಿಲ್ದಾಣದ ಕಡೆಗೆ ಹೋಗುತ್ತಿದ್ದೆ. ನನ್ನ ಹಿಂದೆ ಸ್ನೇಹಿತರಾದ ಲೋಕೇಶ ಹಾಗೂ ಇತರರು ಬರುತ್ತಿದ್ದರು. ನಾನು ಹೋಗುವಾಗ ಹಿಂದುಗಡೆಯಿಂದ ಹುಡುಗಿ ರೇಣುಕಾ ಕೂಗಿಕೊಳ್ಳುತ್ತಿದ್ದರು. ಕಾಪಾಡಿ ಕಾಪಾಡಿ ಅಂತ ಕೂಗಿಕೊಳ್ಳುತ್ತಿದ್ದರು. ನಾನು ಹಿಂದಿರುಗಿ ನೋಡಿದೆ. ಸರ್ಕಾರಿ ಪದವಿ ಕಾಲೇಜಿನ ಮುಂಭಾಗದಲ್ಲಿ ಜನರು ತುಂಬಿಕೊಂಡಿದ್ದನ್ನು ನೋಡಿದ್ದೆ. ನಾನು ಆ ಸ್ಥಳಕ್ಕೆ ಏನಾಯಿತು ಅಂತ ಅಲ್ಲಿ ರೇಣುಕಾ ಜ್ಞಾನ ತಪ್ಪಿ ಕೆಳಕ್ಕೆ ಬಿದ್ದಿದ್ದರು. ಅವಳನ್ನು ನೀರು ಹಾಕಿ ಮೇಲಕ್ಕೆ ಎಬ್ಬಿಸಿದ್ದರು. ಆಕೆಯ ಪಕ್ಕದಲ್ಲಿ ಬಿಳಿ ಬಣ್ಣದ ಕಾರು ನಿಂತಿತ್ತು. ಅದು ಓಮಿನಿ ಕಾರು ಆಗಿದೆ. ಆ ಕಾರಿನ ಸಂಖ್ಯೆ 6746. ನಮ್ಮ ಕಾಲೇಜಿನ ಅಟೆಂಡೆಂಡರ್ ಆದ ಬಸವರಾಜು ಅವರು ಬಂದು ಕಾರಿನಲ್ಲಿದ್ದ 2 ವ್ಯಕ್ತಿಗಳನ್ನು ಮತ್ತು ರೇಣುಗಳನ್ನು ಕಾಲೇಜಿನಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋದ. ಆಗ ಟ್ರಾನ್ಸ್ಫರ್ ದತ್ತಾತ್ರೇಯ ಕಾರಿನಪ್ಪ ಅದನ್ನು ಬಿಟ್ಟಿದ್ದರು. ಅನಂತರ ಪೊಲೀಸರಿಗೆ ಪೊಲೀಸರು ಕಾಲೇಜಿನ ಪಾರ್ಟಿಷನ್ ಯಾರು ನಾನು ಕೂಡ ಹೋದೆ. ಪೊಲೀಸರು ನನ್ನ ಹೇಳಿಕೆಯನ್ನು ಯಾವತ್ತೂ ಬರೆದುಕೊಂಡು ಅಲ್ಲಿನ ನಂಬರನ್ನು ನಾನು ಬರೆದು ಇಟ್ಟುಕೊಂಡಿದ್ದೆ. ನಾನು ಪ್ರತಿದಿನ ಬಸ್ಸಿನಲ್ಲಿ ನಂಬರ್ಗಳನ್ನು ನಾನು ಬೇರೆ ಕಡೆಗೆ ಸುಮಾರು 560 ಜನರು ಸೇರಿದ್ದರು. 50-60 ಜನರು ಯಾರಂತ ನನಗೆ ಹೇಳಲು ಆಗುವುದು. 6 ಇಬ್ಬರನ್ನು ನಮ್ಮ ಕಾಲೇಜಿನ ಅಟೆಂಡರ್ ಸಚಿವರಾಗಿ ಇಟ್ಟುಕೊಂಡಿದ್ದರು. ಪಕ್ಕದಲ್ಲಿ supported when BW 1, 2, 3, 4, 5 and 7 they are all not supported the position.
Yes.
The memo ID at witness of PW. Hello, my is mother of the victim. PW.
Yes.
That's my lord, PW 8, 9, 10 and 11, they were all principal and secretary. They are witness to that these other students who brought this A2 and A1 to the car and kept inside the premises. They are witness for that. Eyewitnesses for that. Now, mother of the ನನ್ನ ಮಗಳು ಆರೋಪಿತರು ನನಗೆ ಗೊತ್ತು. ಈಗ 2 ವರ್ಷದ ಹಿಂದೆ ನನ್ನ ಮಗಳು 10ನೇ ಶಿಕ್ಷಣ ವಿದ್ಯಾಲಯದಲ್ಲಿ 2ನೇ ವರ್ಷದ ಮಾಡುತ್ತಿದ್ದಾರೆ. ನನ್ನ ಮಗಳಿಗೆ ಸಂಜೆ 5 ಅಥವಾ 5:30 ಗಂಟೆಗೆ ಕಾಲೇಜ್ ಇದ್ದಾಗ ಆಕೆ ಹೋಗುವಾಗ ಯಾರು ಅಪಹರಿಸಲು ಪ್ರಯತ್ನಿಸಿದರು ಅಂತ ಕಾಲೇಜಿನಿಂದ ನನಗೆ ದೂರವಾಣಿ ಮೂಲಕ ತಿಳಿಸಿದರು. ನಾನು ಮತ್ತು ನನ್ನ ಗಂಡ ಒಳನರಸೀಪುರ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಬಂದೆವು. ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನನ್ನ ಮಗಳು ಆರೋಪಿತರು ಮತ್ತು ಕಾಲೇಜಿನವರು ಇದ್ದರು. ಆರೋಪಿ ಕೀರ್ತಿ ನನ್ನ ಮೇಲೆ ಜಗಳಕ್ಕೆ ಬಂದಿತ್ತು. ಕೀರ್ತಿ ಈಸ್ ಎಪಿಸೋಡ್ ನಂಬರ್ 1. ಕೀರ್ತಿ ಆರೋಪಿ ಕೀರ್ತಿ ಪದ್ಮಮ್ಮನೊಂದಿಗೆ ನನ್ನ ಮೇಲೆ ಜಗಳಕ್ಕೆ ಬಂದಿದ್ದ. ನನ್ನ ಮಗಳನ್ನು ಅಪಹರಿಸಲು ಪ್ರಯತ್ನಿಸುವುದಕ್ಕೆ ಮೊದಲು ಪದ್ಮಮ್ಮನ ಜೊತೆ ಆರೋಪಿ ಕೀರ್ತಿ ನನ್ನ ಜೊತೆ ಜಗಳಕ್ಕೆ ಬಂದಿತ್ತು. ತಲೆಯಲ್ಲಿ ತಿರುಗದಂತೆ ಮಾಡುತ್ತೇನೆ ಅಂತ ನಮ್ಮ ಮೇಲೆ ಜಗಳಕ್ಕೆ ಬಂದಿತ್ತು. ಅನಂತರ ನನ್ನ ಮಗಳನ್ನು ಅಪಹರಿಸಲು ಪ್ರಯತ್ನವನ್ನು ಆರೋಪಿತರು ಮಾಡಿದರು. ಅವರು ಕಾರಿನಲ್ಲಿ ಅಪಹರಿಸಲು ಪ್ರಯತ್ನಿಸಿದರು. ನಾನು ಕೋಣನೂರಿನ ಅಡಿವಾರ ಸರ್ಕಾರ ಬೀದಿಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ ಎಂದು ಹೆಸರಿತ್ತು. ಸರ್ಕಾರ ನಾವು ವಾಸವಾಗಿದ್ದ ಸಮಯದಿಂದ ರೂಪಾಯಿ ಪ್ರಸ್ತುತ ಇರುವ ನಾನು ಆ ಊರಿಗೆ ಹೋಗುವುದಿಲ್ಲ. ಯಾರಿದ್ದಾರೆ ಎಂದು ಹಾಗೂ ನನಗೆ 5:30 ಗಂಟೆ ನಮಗೆ ದೂರವಾಗಿ ಬಂತು. ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ರಾತ್ರಿ 9:30 ಸಮಯಕ್ಕೆ ನನ್ನ ಹೆಜ್ಜೆ ಪಡೆದರು. ಪದ್ಮ ಚೆನ್ನೀಯ ನಾರಾಯಣ ಅಪ್ಪೂರಿನ ಆ ಅಪ್ಪೂರು ಕೂಡ ನಾವಿರುವ ಸ್ಥಳದಿಂದ 10-12 ರೂಪಾಯಿ ದೂರದಲ್ಲಿದೆ. ಚೆನ್ನಿಗಿರಾಯನ ಅಪ್ಪೂರಿನ ಪದ್ಮನ ಸಹೋದರರಿಗೆ ಯಾವುದು ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಪೊಲೀಸರ ಮುಂದೆ ಅಪ್ಪೂರಿಗೆ ಪದ್ಮ ಅಂತ ಹೇಳಿದೆ. ಸಾಕಿ ಮುಂದುವರಿಸಿ ಪದ್ಮ ಕೋಣನೂರು ಎರಡು ಅಪ್ಪೂರಿಗಳು ನಮ್ಮ ಪದ್ಮ ಅಪ್ಪೂರಿನ ಇರಬೇಕು. ನನಗೂ ಪದ್ಮನಿಗೂ ಕೋಣನೂರಿನಲ್ಲಿರುವ ನಮ್ಮ ಮನೆಯ ಹತ್ತಿರವೇ ಜಗಳವಾಗಿದೆ. ಇವರಿಗೂ ನಮಗೂ ಕೋಣನೂರಿನಲ್ಲಿ ರಾಜ್ಯವಾಯಿತು ಅಂತ ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದಾರೆ. ರಾಜಕಾರಣಿ ನಮ್ಮ ಮನೆಗೆ ಬರ್ತಿದ್ದರು. ಆಗ ನಾನು ರಾತ್ರಿ ಸಮಯದಲ್ಲಿ ಬರಕೂಡದು ಅಂತ ಹೇಳಿದೆ.
The same husband and wife, that is the parents of PW1 has stated same thing. Yes. Then what can you infer from this evidence? I have read the evidence now. Yes. What can be inferred from this evidence?
Support with the motive is shown by other. ಕೀರ್ತಿ ಎಂಬ ಬಂದಿದ್ದ ಜಗಳಕ್ಕೆ ಬಂದಿದ್ದ. ಅವ ಜಗಳ ಮಾಡಿ ನಿಮ್ಮ ಮುಖ್ಯಸ್ಥರಿಗೆ ಕಾಣ್ತೇವೆ ಅಂತ ಅದಕ್ಕೆ ಅಲ್ಲಿ ಮಾಡಿದ್ದ ಅಂತ ಕೇಸ್. This might clear out that only main submission my lord, there are other witnesses along with victim were not supported prosecution case. Then others are all witnesses are supported. That's it. This my submission. You are all friends. were together, but except R6 also supported Chandraya.
What is your argument?
Yes, sir. Sapan eyewitness. Out of total 5 witnesses, PW1 and PW6. PW1 is a victim eyewitness, and PW6 is the eyewitness who engages in the case of prosecution. Though PW2 to 5 turn hostile to the case of prosecution, the evidence of PW6 corroborated.
PW6 is a eyewitness for the occurrence of the incident or
he was just
immediately after the incident.
Yes, he was just 10 to 12 feet away, front of the victim after completion of the college. When he was proceeded towards bus stop, the victim was 12 to 15 feet away from PW6, and on the screaming voice of the victim, he turned to the backside and he saw the incident.
So after hearing the yelling noise or screaming,
Yes,
of when he turned around,
yes.
what he saw? Did he saw the accused pulling the girl and attempting to kidnap?
As per the version of the evidence of PW6, kindly, I would like to draw your worship kind of last of invitation PW6. Sakari.
She had fallen unconscious by the
Yes,
time he turned
yes,
back, right?
Yes.
The other students were trying to woke her up by
Yes.
sprinkling water.
Attender and the other student
Yes.
try to pour the water.
Hmm.
And,
The car was there, accused were there.
Yes.
Hmm.
So at that point of time, the petitioner, the PW6 has not saw the accused number 1 and 2 when the group was there trying to rescue the victim. But he, in the evidence, he deposes that ನಾನು ಆ ಸ್ಥಳಕ್ಕೆ ಏನ ಕಾಪಾಡಿ ಕಾಪಾಡಿ ಅಂತ ಕೂಗುತ್ತಿದ್ದಳು. The evidence of the middle portion of the evidence.
ಗೊತ್ತು, ನೀವು ಸಮ್ಮರಿ ಹೇಳಿ, ಓದೋದು ಬೇಡ.
Yes, yes.
No, you said he is an eyewitness. I am asking you, how do you convince me that he was an eyewitness? Because by the time, even according to him, when he turned around,
Yes.
she had already fallen unconscious.
Yes. But
how can he determine that the accused were attempting to kidnap?
But as far as my humble submission with regard to narrating him as eyewitness, in the evidence he has deposed that he heard the screaming voice of PW1, Kapadi Kapadi. To that extent, I submit this honorable court to.
Then who else are there for your support? If
So
PW1 alone is there.
That extent, PW2, 3, 4 turn hostile to the case of prosecution. So I am handicapped with those witnesses. The evidence of PW1 and with regard to the allegation, the motive on the part of the accused is concerned. The mother and father of victim PW12 and 13 deposes about the prior 1 month in prior to the present incident. The accused accompanied the said Padmamma, made Galata, and the accused number 1 has threatened both PW12 and 13 that they will not be given ನಿಮ್ಮನ್ನ ತಲೆ ಎತ್ತಿ ಇಡೋದಕ್ಕೆ ಬಿಡಲ್ಲ ಅನ್ನುವ ಧಮಕಿಯನ್ನು ಹಾಕಿರ್ತಾರೆ. To that extent, PW12 and 13 have deposed, and nothing contrary was elicited to discard such allegation made against the petitioner. And that too, that your lordship has to appreciate the fact that accused number 1 was present along with said Padmamma on the incident prior 1 month prior to the incident. And the evidence of PW 15 and 16 supports the case of prosecution with regard to PW 15 car seizure major witness. But only I do concede that exhibit ಅನ್ನೋದು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ ಬಟ್ ಕಾರನ್ನು ಜಪ್ತು ಮಾಡಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. And PW 16 is a spot major witness. They have supported both 15 16 have supported the case of prosecution.
Are you sure that PW 15 was a car seizure witness?
He was attender. Yeah, he was a van driver who took the president, secretary, and the school children, college student to the police station along with the accused, and he deposes that in the station that car was being seized in his presence.
So he was not car seizure witness then.
He narrated the.
No, in the beginning you said he's only a car seizure witness and you skipped PW 16. When I asked you to that whether you are sure that he is only a car seizure witness, now you are coming up with a different story that he carried the accused and the carriage staff to the police station.
Yes, yeah. In the evidence of that unity of the court, I will go with the evidence of the
HCGP, don't confuse yourself.
Yes.
New ಮೊದಲಿಗೆ PW 15 seizure witness, car seizure witness.
Yes.
However, I fairly concede that through him the car seizure Panchanama has not been marked ಅಂತ ಹೇಳಿದ್ರಿ.
My humble submission to this, while the prosecutor examining the PW 15, ಅಲ್ಲಿ PW 15 ಅಂತ evidence
ಅದನ್ನ ಎವಿಡೆನ್ಸ್ ತೆಗೆದು ಓದಿ ಮತ್ತೆ ಫರ್ದರ್ ತೇಪೆ ಹಚ್ಚಬೇಡಿ ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ನಿಗೆ. ನೀವು ಫಸ್ಟ್ ಹೇಳಿದ್ದು PW 15 was a car seizure witness. However, you said that I fairly concede that car seizure Panchanama was not got marked through him. Andri, ಆಮೇಲೆ PW 16 ಗೆ ನೀವು ಹೋದ್ರಿ, ಸ್ಪಾಟ್ ಮಾಜರ್ ವಿಟ್ನೆಸ್ ಅಂದ್ರಿ. ಅವಾಗ ನಾನು ನಿಮ್ಮನ್ನ ಕೇಳಿದೆ whether are you sure that the role of PW 15 is confined only to the seizure of the car.
Yes.
Then you come up with a different story. Did you not say that PW 15 took principal, lecturer, staff with the accused to the police station?
Yes.
Then is it not a different than what you initially stated that PW 15 is only a car seizure witness?
I will make corrections. The
Correction
role,
not permitted. Correction is not permitted.
the role of PW 15
I am only ascertaining that how often in every matter you keep on changing your version, but never concede fairly that you made a incomplete submission or an incorrect submission.
One submission to this honorable. As a whole, the role of PW 15 is concerned. First, he took the students, president, secretary to the police station in his vehicle. Thereafter, in the station, the police draw the major. To that extent, he deposes police in For that, in continuing my argument, I have stated the prosecutor has not got marked that Panchanama. That is my substance of argument.
Yes, then.
And the PW 16 is the spot Panchanama witness who was attender of the school college. So my humble submission to this honorable court, considering the evidence of PW 1, PW 16, and the PW 12 and 13, who deposes about the motive on the part of accused, and one more witness is PW 17, owner of the car, deposes about on the prior date of the incident, A2 took the car from him. To that extent, role of A2 in the involvement, and as far as the victim also deposes that he has dragged her into the car. So the prosecution has substantiated that case against both accused number 1 and 2 with cogent evidence. So the learned trial judge has rightly convicted both the accused for the offences. And after pre-appreciation of the evidence, the first appellate court confirmed the order of convictions.
Any
So
reply?
the reason is
that the interested witness was convicted because he is only stated that the unconscious only by his own. But that he stated that statement. That
Yaru.
PW1 also not stated that about their unconscious.
No, what is not stated by PW 15? You said PW 15 is only stated. No, what in reply, what statement you made, please? ತಾವ್ ಏನ್ ಹೇಳಿದ್ರಿ ಈಗ ರಿಪ್ಲೈಲಿ ಇನ್ನೊಮ್ಮೆ ಹೇಳಿ ದಯವಿಟ್ಟು. PW1 ನಾನು ಹೆಸರು ತಪ್ಪಿ ಬಿದ್ದೆ ಅಂತ ಹೇಳಲಿಲ್ಲ ನಿಮ್ಮ ಪ್ರಕಾರ. ಮುಂದೆ ಹೇಳಿ ಕೂತ್ಕೊಳ್ಳಿ. Other matters in the afternoon after completion of this dictation. Yes. Affirmation of conviction against offences. The summary of the case of the prosecution in the trial court was that on the date 23/12/2008 at about 5 p.m. when PW1 CW1 Renuka, who was a student of Diploma in Education DED course at Bharat Universal DED College, Old Mysuru, after completing the classes, was returning to her room along with her friends, along with her classmates, Miss Pavitra, Miss Rukmini, Miss Shivamma, and Miss Sumalata, and going on Degree College Road. At that time, from the side of the college, a Maruti Omni car came, and coming near to her, a person sitting in the car opened the door and attempted to pull the complainant inside the car forcibly, and thus to kidnap and thus to abduct her. However, when the complainant and her classmates come friends who were with her raised hue and cry, the other college students, including Kantraju, Chandraya, and Lokesh, who heard the yelling for help, rushed to them and rescued her from the accused. Accused them from the accused and took the accused. Accused them from the accused. The principal, Dattatri, the secretary Shri K.V. Shambulingappa, and the lecturers Shri Virendra Babu and one Shri Basuraj, took the accused into their possession and took both accused Kirti and Lingaraju to the police station in a separate vehicle, where the police recorded the complaint, registered the complaint given by the complainant, conducted investigation, and filed charge sheet against the accused. Where the police registered the information complaint given by the informant, PW1, registered the crime. After completing the investigation, the police filed charge sheet against both the accused for the offence punishable under section 365 read with section 511. 365, 511 read with section 34 of Indian Penal Code. Points learned. Counsel for the petitioner in his brief argument mainly canvassed only on one point, that in view of CW2, CW3, CW4, and CW5, who were said to be the eyewitnesses and the classmates accompanying the complainant at the time of incident, having not supported the case of prosecution about the incident, the trial court was at the error in believing the evidence of other witnesses and holding the accused guilty of the alleged offense. The counsel submitted that even the session judges court also repeated the same error. Thus, the petition deserves to be allowed. For control, HCGP in his brief argument submitted that the evidence of PW1 being the victim in the incident, the victim and informant in the incident is trustworthy, believable. As such, the evidence of an injured witness or the victim is sufficient to believe and sufficient to convict the accused for the alleged offense. He further submitted that evidence of PW12 and 13, the parents of the victim girl, gives the detailed account, mentions about the motive behind the alleged crime and the quarrel between PW13 and their distant relative Padmamma a month prior to the incident, at which time the accused number 1 was said to have threatened PW13 that he would see that they would not show their face in society with respect. He also submitted that the evidence of PW17, the owner of the car, also go to show that it was accused number 2 who had taken the car for his use on the previous day from PW17, and that PW17 came to know about the misuse of the said car for the alleged crime only after his return to his place next day of the incident. This is submitted. It is considering these aspects, since the trial court has appropriately held the accused guilty, rightly held the accused guilty for the alleged offense and convicted him, which was further confirmed by the session judges court, the same do not warrant any interference at the hands of this court. Next line, analysis of evidence. Madhyana, continue.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಆಮೇಲೆ ನಾನು ನಮ್ಮಿಂದ ಹೋಗಿದೆ ಹೋಗಿದೆ ಹಾಂ 10 ಇವತ್ತೇ ಡೇಟ್
ಇದೇನಾದ್ಮೇಲೆ
ಹಾಂ ಇವತ್ತು ಪೋಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಆರ್ಡರ್ ಆಯಿತು
ಈ ಮೆಮೊ ಇವತ್ತು ಮೂವ್ ಮಾಡಿರೋದ ಮೊನ್ನೆದ? ನಾನು ಹೇಳ್ತಿದ್ದೇನೆ, ಅದನ್ನ ಹೇಳ್ಬೇಕು ನೀವು. ಇದೇ ಮೆಮೊ ಅಂದ್ರೆ 2 ಮೆಮೊ ಇದೆ ಇದ್ರಲ್ಲಿ, ಒಂದು ಇವತ್ತಿಂದು ಒಂದು ಮೊನ್ನೆದು. ಮೊನ್ನೆ ಮೆಮೊ ಅಲ್ಲಿ ಹೋಗಿದೆ ಎನ್ಲಿಕ್ಕೆ ಎಲ್ಲಿದೆ? ಈಗ ನಾವು ಸಬ್ಮಿಷನ್ ಕೇಳಿದ್ದೇವೆ ಅಲ್ವೇ? ಸಬ್ಮಿಷನ್ ಯಾರಿಂದ ಕೇಳಿದ್ದೇವೆ? ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಯಾರಿಂದ ಕೇಳಿದ್ದೇವೆ? ಮತ್ತೆ ಅದನ್ನ ಯಾರು ಹೇಳ್ಬೇಕು ಮೆಮೊ ಬಂದಿದೆ ಅಥವಾ ಇಲ್ಲ ಅಂತ? ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ. ಮತ್ತೆ ನೀವು ಮೆಮೊ ಇಲ್ಲಿಂದ ಹೋಗಿದೆ ಅಂದ್ರೆ ಅದನ್ನ ತಗೊಂಡೋದನ್ನ ವೆಂಕಟೇಶ್ ಅದನ್ನ ನುಂಗಿರ್ಬೋದು. ಅವ್ರಿಂದ ಬರ್ಲಿ. ವಿಜಯಲಕ್ಷ್ಮಿಗೆ ಹೇಳಿ ಅವರು ರುಪಿ ಫಂಡ್ ಯೂಸ್ ಮಾಡ್ತಿಲ್ಲ RS ಅಂತ ಹಾಕ್ತಿದ್ದಾರೆ. ಸೈನ್ ಮಾಡಲ್ಲ, ಅವ್ರು ಈಚ್ ಪೇಜ್ 5 ರೂಪಾಯಿ ಕಟ್ಬೇಕಾಗ್ತದೆ ಕೋರ್ಟಿಗೆ. ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿ ಅವ್ರಿಗೆ. ಅಪಾಟಿ ಸೋಮಾರಿ ಆಗ್ಬಾರ್ದು ಕೆಲಸದಲ್ಲಿ ಅಂತ ಹೇಳಿ. ಸ್ಟಾರ್ ಹಾಕಿದ್ದೇನೆ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. If he is found correct, quote me. But in the registry, in the matter, come. Still the learned counsel adheres. Yes. Serial number
38.
Ha.
I have to address my argument.
38.
Lordship has directed to get the control order of kerosene.
I did not direct you to do anything, please. ನೀವು ಮಾಡ್ಬೇಕಾಗಿರೋದು ನಿಮ್ಮದನ್ನ ಕೋರ್ಟ್ ತಲೆಗೆ ಕಟ್ಟಬೇಡಿ. ಕೋರ್ಟ್ ನಿಮ್ಮನ್ನ ಕೇಳಿತು. Whether how do you say that kerosene was an essential commodity? ಅಂತ ನೀವು ಸೆಕ್ಷನ್ 7 ಅನ್ನ ಓದಿದ್ರಿ. ಆಯಿಲ್ ಇದು ಅಂತ ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ ಕೆರೋಸಿನ್ ಆಯಿಲ್ ಅಂತ ಹೇಗೆ ಹೇಳ್ತೀರಿ ಅಂತ ಹೇಳಿದಕ್ಕೆ ಅವಾಗ ನೀವು ಹೇಳಿದ್ರಿ ಐ ವಿಲ್ ಗೆಟ್ ಸಮಥಿಂಗ್ ಅಂತ ಎಲ್ಲ. ಕೋರ್ಟ್ ಡೈರೆಕ್ಟೆಡ್ ಅಂತ ಮಾಡಬೇಡಿ. ಎಲ್ಲರಲ್ಲೂ ಅದೊಂದು ಅಭ್ಯಾಸ ಇದೆ ನಿಮ್ಮಲ್ಲಿ. ನಿಮಗೆ ಒಳ್ಳೇದಕ್ಕೆ ಕೋರ್ಟ್ ಏನಾರು ಹೇಳಿದ್ರೆ ಕೋರ್ಟ್ ಡೈರೆಕ್ಟೆಡ್ ಅಂತ ನಮ್ ತಲೆಗೆ ಕಟ್ತೀರಿ. ಮಾಡಬೇಡಿ. ಹೇಳಿ ಏನು ಮುಂದೆ. ಹೇಳಿ ಮುಂದೆ.
That order just at 12 o'clock I have received. I will go through it and make my if your lordship place it for tomorrow or day. I will.
Called again, learned counsel from both sides present. Learned SCGP stating that he is yet to go through the case, go through the file in detail, press for a day's accommodation. List the matter on. ನಾಳೆಯ ನಾಡಿದ್ದ inconvenience.
Convenience.
List the matter on. ಐದು ತಾರೀಕು ಹೇಗಿದ್ದೀರಿ? 5. ಅದೊಂದು ಕಾಪಿ ಏನಿದೆ
Hello. Hello. ಇದು ಜಾಸ್ತಿ ಬಿಟ್ರೆ ಇಲ್ಲ ವೈರ್ ಕಮ್ಮಿ ಇದೆ ಇಲ್ಲೂ ಸ್ವಲ್ಪ
ಸರ್ ಸರ್ ಏನು ಯೂಸ್ ಮಾಡಬೇಕಾ ಏನು ತಗೊಂಡು ಸರ್ ತುಂಬಾ ಮೇಲೆ ಹೋಗಿದ್ದಾರೆ ಝೂಮ್ ಆಗ್ತದೆ ಫ್ಯಾನ್ ಎಸಿ ಎಲ್ಲ ಬೈಕ್ ಅಂತ ತುಂಬಾ ಹತ್ರ ಕಾಣ್ತಾ ಇದೆ ಬೇರೆ ಇನ್ನೂ ಕವರ್ ಆಗಿದೆ
ಕಲಬುರ್ಗಿ ಬೆಂಚ್
ಹಾ ಸರ್
ಗೌಸಿಯಾ ಬೇಗಮ
ಹಾ ಸರ್
ಗೌಸಿಯಾ ಮೇಡಮ್
ಹಾ ಸರ್
ಯಾರಿದ್ದೀರಾ ಈಗ ಅಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ ಇದ್ದೀರಾ
ಹಾ ಸರ್ ಕೂಡ ಇಲ್ಲೇ ಇದೀನಿ
ಅದ್ರಲ್ಲಿ ನಿಮ್ದು ಆಗಿದ ತಕ್ಷಣ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಲಾಗ್ ಆಫ್ ಮಾಡಿ ಮೇಡಮ್ ಮರೀದಂಗೆ
ಆದ ತಕ್ಷಣ ಲಾಗ್ ಆಫ್ ಮಾಡಲ್ಲ ಸರ್
ನಿಮ್ದು ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಗುತ್ತಲ್ಲ
ಹಾ ರೀ
ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಗಿದ ತಕ್ಷಣ ಲಾಗ್ಔಟ್ ಮಾಡ್ಬಿಡಿ ನೀವು
ಹಾ ಸರ್
ಓಕೆ ಮತ್ತೆ ಆಯ್ತು ಮರೀದಂಗೆ ಲಾಗ್ಔಟ್ ಮಾಡಿ
ಇಲ್ಲ ಸರ್ ಮಾಡ್ತೀನಿ ತಗೋ ಸಾಹೇಬ್ರು ಕೇಳಿ ಲಾಗ್ ಆಫ್ ಮಾಡ್ಬೇಕು
ಹಾ ಓಕೆ
ಓಕೆ ಸರ್ ಹಲೋ ಸರ್ ಸರ್
ನಾವು ಊಟ ಮಾಡ್ಬೇಕು, ಬೇಗ ಹೇಳಿ ಗೌಸಿ.
ಇಲ್ಲ ಸರ್, ಇಲ್ಲ ಓಕೆ, ಇಲ್ಲ ಕ್ಲಿಯರ್ ಇದೆಯಲ್ಲ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೆ ಅಷ್ಟೇ.
ಹಾ, ಕ್ಲಿಯರ್ ಇದೆ.
ಓಕೆ, ಊಟ ಮಾಡಿ ಸರ್.
ಓಕೆ.
ಯಾರು ಕನೆಕ್ಟ್ ಶ್ರೀಶೈಲ ಅವರಾ? ಹಲೋ, ಹಲೋ.
Yashkan sir.
Kalaburgi bench.
Yes, sir.
ಸರ್ ಅವರ ಇದು ಆಕ್ಚುಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದಾರೆ ಯಾರಾದ್ರು?
ಹಾ ಸರ್, ಹೇಳಿ ಸರ್.
ಗೌಸಿ ಮೇಡಮ್ ಫೈಲ್ಸ್ ಎಲ್ಲ ಬಂದಿದ್ಯಾ?
ಇಲ್ಲ ಸರ್, ಇನ್ನು ಚೇಂಬರ್ ಅಲ್ಲಿ ಸಾಹೇಬ್ರು ಫೈಲ್ ನೋಡ್ತಾ ಇದಾರಂತ್ರಿ.
ಅಲ್ಲ 2 ಸೆಟ್ ನಿಮ್ಮಲ್ಲೇ ಇದೆಯಲ್ಲ?
ಹಾ 2 ಸೆಟ್ ನಮ್ಮಲ್ಲೇ ಇದೀರಿ, ಕಲಬುರಗಿ ಬೆಂಚ್ ಅಲ್ಲೇ ಇದೀರಿ.
ಅಪ್ಡೇಷನ್ ನೀವೇ ಮಾಡ್ಬೇಕು.
ಏನ್ ಸರ್?
ಅಪ್ಡೇಷನ್.
ಹಾ ಸರ್, ಅಪ್ಡೇಷನ್ ನಾನೇ ಮಾಡ್ತೇನೆ. ಹಾ ಸರ್, ಇಲ್ಲಿ ಬರ್ತಾ ಇದೀರಿ, ಇಲ್ಲಿ ಮಾಡ್ತೀನಿ, ನಾನೇ ಮಾಡ್ತೀನಿ.
ಅದೇ ಇದಕ್ಕೆ ರಿಸಲ್ಟ್ ಅಪ್ಡೇಷನ್ ನೀವೇ ಮಾಡ್ಬೇಕು, ಯಾಕಂದ್ರೆ ನಾವು ತೋರ್ಸಕ್ಕೂ ಆಗಲ್ಲ ಏನೂ ಇಲ್ಲ.
ಎಲ್ಲ ನಾನೇ ಮಾಡ್ಕೊತೀನಿ ಸರ್.
ಸರಿ, ನಿಮ್ ಮುಗಿದ ತಕ್ಷಣ ಅಲ್ಲೇ ಲಾಗ್ ಆಫ್ ಆಗ್ಬಿಡಿ ಮೇಡಮ್.
ಓಕೆ ಸರ್, ಓಕೆ ಓಕೆ ಸರ್. ಸಿಗ್ನೇಚರ್ ಸಾಹೇಬ್ರಿಗೆ ಮಾಡಿಸ್ಲಾ ಸರ್? ಅನೌನ್ಸ್ಮೆಂಟ್ ಆದ ತಕ್ಷಣ ಸಾಹೇಬ್ರಿಗೆ ಸಿಗ್ನೇಚರ್ ಮಾಡಿಸ್ಲಾ ಸರ್?
ಮಾಡಿಸ್ಬೇಕಲ್ವಾ?
ಇಲ್ಲ ಅಂದ್ರೆ ಸೀನಿಯರ್ ಸರ್ ಅಲ್ಲೇ ಇದಾರಲ್ಲ, ಅದಕ್ಕೆ ಸರ್.
ಫಸ್ಟ್ ಜೂನಿಯರ್ ಸಾಹೇಬ್ರೆ ಮಾಡೋದು, ಆಮೇಲೆ ಸೀನಿಯರ್ ಬರುತ್ತೆ.
ಓಕೆ ಓಕೆ, ಅದೇ ಒಂದ್ ಸ್ವಲ್ಪ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಆಯ್ತು. ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಮಾಡಿಸ್ತೀನಿ. ಹಲೋ
ಶ್ರೀಶೈಲ್.
ಹಾ ಸರ್, ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ಕಾಣ್ತಾ ಇದಾರ ಅಂತ.
ಇಲ್ಲಿ ಶ್ರೀಶೈಲ್ ತಾನೇ ಅಲ್ಲಿ ಇರೋದು?
ಹಾ ಸದಾಶಿವ್ ಸರ್.
ಸದಾಶಿವ್, ಸದಾಶಿವ್ ನೀವು ಮಾತಾಡೋದು ಕೇಳಿಸ್ತಿಲ್ಲ. ಸ್ವಲ್ಪ ಲೈಟ್ ಆಗಿದೆ, ತುಂಬಾ ಕಟ್ ಕಟ್ ಆಗ್ತಾ ಇದೆ. ಕಟ್ ಕಟ್ ಆಗ್ತಾ ಇದೆ. ಆಮೇಲೆ ಅದು ನಿಮ್ದು ಮುಗಿದ ತಕ್ಷಣ ಲಾಗ್ಔಟ್ ಮಾಡಿಸ್ಬಿಡಿ ಸರ್ ಕ್ಲೀನ್ ಆಗಿ. ಯಾಕಂದ್ರೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಹಿಂಗೆ ಆಯ್ತು, ಅವ್ರು ಸಾಹೇಬ್ರು ಅಲ್ಲೇ ಕೂತ್ಕೊಂಡೇ ಇದ್ರು. ಸಾಹೇಬ್ರು ಈ ಕಡೆ ನೋಡ್ತಾ ಇದ್ರು, ಇವ್ರು ಆ ಕಡೆ ನೋಡ್ತಾ ಇದ್ರು. ಆತರ ಆಗ್ಬಾರ್ದು, ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಹೆಂಗೆ ಕಂಟಿನ್ಯೂಷನ್ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ ಇಮಿಡಿಯೇಟ್ ಲಾಗ್ಔಟ್ ಮಾಡಿಸಿ.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್, ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದ್ದೀರಾ?
ಹೇಳಿ ಸರ್. ಹಲೋ.
ಮೇಡಮ್.
ಹಾ ಸರ್, ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ತಾ ಇದೆ, ಹೇಳಿ.
ಮಂಡೇ ಒಂದು ಮ್ಯಾಟರ್ ರೀಡ್ ಕಂಪ್ಲೇಂಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ರು. ಮಂಡೇ ರೀಡ್ ಅಲ್ಲಿ
ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲ ಸರ್?
8 ಕೋರ್ಟ್ ಹಾಲ್ ರಿವಿಷನ್.
ಇಲ್ಲ ಸರ್, ಈಗ ಇದು ಡಿಬಿ ನಡೀತಾ ಇರುತ್ತೆ ಸರ್, ಇದು ಡಿಬಿ ಬೆಂಚ್ ರೀ ಇದು.
ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಮೇಡಮ್.
ಸರ್ ಯಾವ ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರಾ ಸರ್? ಹಲೋ ಸರ್, ಬೆಂಗಳೂರು ಮ್ಯಾಟ್ರಾ?
ಹೌದು, ಅದು
ಇಲ್ಲ ಸರ್, ಇದು ಡಿವಿಷನ್ ಬೆಂಚ್
ಕಲಬುರಗಿ.
ಸರ್ ಇದು. ಸಿಂಗಲ್ ಬೆಂಚಾ ಸರ್?
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದ್ದೀರಾ? ಕಲಬುರಗಿ ಮೇಡಮ್, ಕಲಬುರಗಿ ಬೆಂಚಾ?
ಹಾ ಸರ್.
ಪಾಸ್ವರ್ಡ್ ಇದು ಬೆಂಗಳೂರಿಗೆ ಪಾಸ್ವರ್ಡ್ ಬುಕಿಂಗ್ ಐಡಿ.
ಹಲೋ ಸರ್, ಕಲಬುರಗಿ ಬೆಂಚ
ಹಾ ಸರ್, ಕಲಬುರಗಿ ಬೆಂಚ್.
ಮೇಡಮ್ ಸಾಹೇಬ್ರು ಬಂದ್ರ?
ಹಾ, ಬರ್ತಾ ಇದ್ದಾರೆ.
ನಮ್ ಸಾಹೇಬ್ರು ಬರ್ತಾ ಇದಾರೆ, ಅದಕ್ಕೆ.
ಹಾ.
ಮೇಡಮ್ ಬಂದ್ರು.
ಮೊದಲು ಡಿವಿಷನ್ ಬೆಂಚ್ ಮಾಡಿ. ಅನ್ಕೊಡು. ಬರ್ರಿ.
Announcement of judgment from Kalburgi.
Yes.
Yes, brother. Good afternoon.
ನಮ್ಮ ಫ್ರೆಂಡ್ಸ್ ಬಂದ್ರಿ ಸರ್. ಡಿವಿಷನ್ ಬೆಂಚ್ ಮಾಡಿ.
Division bench matters, announcement of judgment, serial number 1, B. Sintaka, additional SCP.
ಅವನಿಗೆ ನಮ್ಮ ಫ್ರೆಂಡ್ಸ್ ಜೊತೆ ನಿಂತ್ಕೊಂಡು ಅಂತ criminal appeal 643 and 64. Appeal is both the appeals are partly allowed. The judgment of conviction is modified as under the accused are convicted under section 325 instead of 356 and acquitted for 326, 325 of SC/ST Act. The rest of the remaining follows.
Brother.
Yes, please.
ಅದರಲ್ಲಿ ಈಗ ಪ್ರೊನೌನ್ಸ್ ಮಾಡಿದ್ರಲ್ಲಿ ಅಮಿಕಸ್ ಕ್ಯೂರೆ ಇದ್ದಾರೆ. ಸೊ ಅಮಿಕಸ್ ಕ್ಯೂರೆದೊಂದು ಸರ್ವಿಸಸ್ ನ ಅಕ್ನಾಲೇಜ್ ಮಾಡಿ ಅವರಿಗೊಂದು ಆನರೋರಿಯಂ ಒಂದು ಸೇರಿಸಿ ಬಿಡಿ ಅದರಲ್ಲಿ.
ಆಯ್ತು ಸರ್.
Serial number 2, A.L. Krishna Swami, Shivanand Patil.
Criminal case 2020-70/2014.
The Lordship, in the first matter, my lord.
Yes.
In first matter, my lord, I was appointed as a counsel, my lord. The amicus curiae was removed, my lord, after payment of fine of 5,000, my lord, on that day.
Yes, sir.
Sushana Reddy.
Brother, in that says subsequently order agide sir, so he has to take note of it.
Amicus curiae was removed and I was permitted to argue.
Yes. The appeal is partly allowed. The judgment or award of the tribunal is modified and compensation of 1,01,89,879 is.
Serial number 3, Shivanand Patil.
MFA 200000581. The appeal filed by the appellate petitioner is hereby dismissed as devoid of any merits. The judgment of the trial court is confirmed.
Serial number 4, Ajay Kumar A, Rama N. Shivakumar.
MF 200381. The appeal filed by the appellant is hereby dismissed as divide of merit. Judgment of the trial court is confirmed.
Serial number 5, Sanjeev Patil. This is Aspalli.
MF 200610. The appeal filed by the appellant's claimant is hereby partly allowed. Compensation amount enhanced to 11,48,000. The difference amount is the entire amount is ordered to be paid to the claimant with interest. All 5 judgments are over, sir.
Thank you, brother.
Thank you, brother. Thank you. Switch on my door.
ಯಾವುದು invitation ಕರೆದ್ರೆ ಆಮೇಲೆ ಪಾಸ್ ಆಗುತ್ತೆ.
Number 41. Not for respondent.
The removal of the evidence of the prosecution witnesses, more particularly the evidence of PW1, PW2, PW1, PW6, PW7, PW8, PW9, PW10, PW11, with the evidence of PW14 and PW15 shows that the alleged incident of somebody attempting to abduct PW1, CW1 Renuka on 23/12/2008 at about 5 p.m. near her college at so and so road stands established. Incidentally, in none of the cross-examination of the above witnesses from the accused side, it was not denied about the occurrence of the alleged incident of attempt to abduct PW1, CW1 Renuka. However, the entire endeavor of the defense was that such an act was not committed by the accused. In fact, evidence for the PW2. Even though PW2, PW3, PW4 and PW5 treated as hostile by and permitted to be cross-examined by the prosecution. But their evidence in examination chief that all of them came to know that on the date of incident, somebody attempted to abduct Renuka has remained undenied. It is for the simple reason that none of these witnesses were cross-examined from the accused side. Therefore, the evidence of these four witnesses about the alleged incident that they came to know that there was an attempt to abduct PW1 has remained undisputed. Okay. The details about the alleged incident and the role of the accused in the alleged incident has been in detail narrated by none else than PW1 Renuka, who is the victim herself. It's not in dispute that she was the student of so college ಬೆಳಗ್ಗೆ ಹೇಳಿದೆ ನೋಡಿ ಭಾರತ್ so BED college, Bharat Universal B.Ed college in Old Mysore, and that on the date of incident, that is 23/12/2008, she attended the class from morning till evening. The attendance certificate Exhibit P9 issued by the principal of the said institution also go to show that on the date of incident, PW1 attended the college from 10 a.m. to 5 p.m. The witness has PW1 has stated categorically that while she was returning to her room along with her classmates, including PW2 to PW5, Maruti Omni car came near to her, and one of the persons sitting inside attempted to pull her inside the car. However, she resisted and raised hue and cry. She has stated that she was not put inside the car since she resisted for such an attempt. It was that she raising hue and cry along with her classmates, that is PW2 to PW5, who were accompanying her. The other students and staff who were walking on the same road were alarmed and they reacted immediately. The presence of the other persons, that is the other students and the staff, also cannot be disbelieved for the reason that according to PW1 as well, PW8, the principal, the place of the incident was only at a distance of about 100 meters from the college. As such, after college hours, the students and staff moving on the main road to go to their home is quite natural and expected. PW2, 3, 4, and 5 though have stated that they are classmates of, they were the classmates of PW1. But about the incident, they have expressed their ignorance, except stating that they came to know that such an incident had taken place. However, according to prosecution, however, it's not just PW 2 to 5 who were eyewitnesses to the incident and who were the eyewitnesses to the incident, but there are other witnesses who also have stated about the incident as seen and as seen by them. PW6 para has stated that he heard the yelling noise of PW1 for help, and immediately he turned back and saw that PW1 had fallen on the ground and few people had gathered. He took 2 steps to reach her, only to see that the people gathered there were sprinkling water on her. The accused were retained by the people gathered there, and the Maruti Omni car alleged is said to have been used by the accused in the commission of crime was also parked there. The witness has thus made it clear that he has seen the victim and the accused and also the car in this spot. Though at one place the witness has stated he saw the accused pulling PW1 inside the car. However, his statement that the statement of PW1 that she resisted she being put inside the car and she was not put inside the car would prevent from accepting the statement of PW6 that he saw PW1 being put inside the car. With other evidence that he saw the accused car and the people gathered there could not be shaken in the cross-examination. The evidence of PW7 not be shaken. PW14 and PW15 have stated that they have seen the occurrence of the incident. PW14 has categorically stated that he is the governing council member of this management of the college where the complaint was studying. He has stated at the time the incident took place, he was moving on the he was near the college and saw the car coming near complainant and the person inside the car attempting to pull complainant Renuka inside the car. The witness has further stated that he too rushed to the spot and saw that the other people gathered there had restrained both the accused from moving further along the car. It's thereafter the accused and the car were brought to the college and the police were summoned and the police were informed and the accused were handed over to the police. The witness adhered to his original version in his cross-examination. The evidence of PW15 is also to the same effect that he has seen the occurrence of incident. And later on, it was in his tracks vehicle. Both the accused, the staff of the college were taken to police station. Police station. Thus, the evidence of PW 14 and PW 15 further shows that it is not just an incident that has taken place, but the persons who committed the alleged act of attempt to abduct was done by none else than the accused. None else than the accused. PW 8, the principal, PW 9, the secretary of the college, PW 10, PW 11, who were the lecturers of the college, have all uniformly stated that on the date of incident in the evening, immediately after occurrence of the incident, the accused along with the car and the complainant were brought to the chambers of the principal, and it was revealed before them that both the accused attempted to abduct PW1 Renuka. Principal has even gone to the extent of stating that for the safety of the accused, since there was an apprehension of the students gathered there, causing some harm to them, he retained both the accused in his chamber, and later they were handed over to the police. Later they were handed over to the police. The cogent evidence given by PW8, PW9, PW10, and PW11 on the point further corroborates the evidence of PW1, PW6, PW14, and PW15 about not only the occurrence of incident of alleged attempt to abduct PW1, but also the involvement of both the accused in the commission of the said offense. PW6, PW8, PW9, PW10 have even identified both the accused in the court as the very same persons who were apprehended by the gathering in the place and produced those two accused before the principal and the lecturers, and thereafter before the principal and thereafter in the police station. Well, to the height of the evidence of these material witnesses, the evidence of PW 17 also strengthens the case of the prosecution, who, being the owner of the car, had stated that on the previous day of the incident, his car was taken by accused number 2, Ningaraja, for his personal use. The witness has stated it was not for the first time they said the accused was taking his car, and now and then he was taking his car as such. He had given his car to him on 22/12/2008. 22/12/2008, stating that he has to go to the house of his relatives. The witness has further stated that since he went to Bengaluru to visit his ailing uncle who had undergone a heart surgery, he returned to his place 2 or 3 days afterwards, and only then he came to know that his car was seized by police, and through the police, car was seized by the police and came to know about the incident, and then got the interim custody of the car. The said evidence of none else than the owner of the car, itself go to show that the car in question was given temporarily to the possession of accused number 2 on the previous day of the incident. And after the incident, the owner of the car came to know that his car was involved in the offense in question, and accused number 2 had taken the said accused number 2 was in possession of the car at that time. Thus, the possession of the car at that time. The evidence of PW18, the doctor, shows that on 23/12/2008 in the night at 9:45 p.m., the victim, along with her mother, had been to the government hospital where PW18 was the medical officer. And the doctor examined the complainant and issued a noticing some simple injury on her, has issued a wound certificate as per Exhibit P10. The said evidence of the doctor and the wound certificate which also shows that the complainant had sustained a tenderness on the nape of the neck and a tenderness on the right elbow joint, which were with simple injuries, was affected in the incident. Thus, the evidence of none else than the complainant and the victim as PW1, which is further corroborated by the evidence of PW6, PW8, PW9, PW10, PW11, PW8, PW14, and PW15 would go to show PW15, PW17, and PW18 go to show that the alleged incident has taken place where the present petitioners were the accused who had committed the alleged act. The description of the spot given by all these witnesses about the place of the incident has been further corroborated by evidence of PW16, who has stated that the scene of offense Panchanama as per Exhibit P3 was drawn in his presence. Even PW1 also has stated that it was she who shown the spot to the police and the Panchas to enable them to draw scene of offense Panchanama as per Exhibit P3. The subpara seizure of the motor car is corroborated by the evidence of PW1, who has identified the seizure Panchanama at Exhibit P2. Incident P2. Moreover, the very evidence of PW17 that his car was seized for the alleged involvement in the alleged offense also would go to show that it was the very same car bearing registration number KA02M6740 got involved in the commission of crime, which car incidentally was given for its temporary use and possession by PW17 to accused number 2 on the previous date of incident. Thus, these evidence would take away the impact of non-supporting by PW2, PW3, PW4, and PW5 about the incident. Therefore, the argument of the learned counsel for the petitioner that in the absence of supporting evidence by PW2 to PW5, who were said to be the classmates accompanying PW1 at the time of incident, the evidence of other witnesses cannot be believed, is not acceptable. On the other hand, the prosecution not acceptable. On the other hand, fair. The evidence of PW12 and PW13, who were admittedly the parents of PW1, attributes the motive behind the alleged crime. In the form of suggestion made to PW1 from the accused side, an attempt was made to show that one Srimati Padmamma was known to the family of the complainant. Attempt was made of that. It was elicited. It was elicited in the cross-examination of PW1 that one Srimati Padmamma of K. Abbur was known to the family of the complainant. Parents of the complainant, that is PW13 and PW12 and PW13 also have stated that said Padmamma is their distant relative. However, both of them have stated that she is like a politician and was visiting their house in the late nights. Both the witnesses have also stated that she said Padmamma was asked not to visit their house in the late night, for which she was not happy. In one such occasion, said Padmamma had brought accused number 1, Kirti, with her, who had threatened the parents of the complainant that he would see that they would not able to show their face in the society. Said incident, according to PW 12 and 13, was said to have occurred just a month prior to the incident in question. Thus, it is also brought by the prosecution that he said Kirti, who is accused number 1, joined by accused number 2, had attempted to abduct the daughter of PW 12 and 13 on 23/12/2008 at 5 p.m. in a public place, only to take her away. Which in turn amounts to confinement of PW1 by the accused. The accused had taken a sole defense in the cross-examination of the witnesses. In the cross-examination, sole defense that in connection with the old matter between mother of the complainant and one Padmamma, a false case has been lodged against the accused. However, the said suggestion was not admitted as true by PW1, except making a suggestion that with respect to an old incident, nowhere any attempt was made from the accused side as to what was that alleged old incident was and how, when and how did that occur. As such, a bare and a vague suggestion made to PW1 in her cross-examination, as the defense for accused also could not favor the accused in weakening the evidence of the prosecution material witnesses, including the victim herself, the college staff, and other eyewitnesses to the incident. Thus, it is appreciating these aspects in their proper perspective, since the trial court has convicted the accused for the alleged offence, which was further confirmed by the Session Judges Court. I do not find any reason to interfere with that. It is the trial court sentenced the accused to undergo so and so. Body sentencing policy ಮಾಡಿ does not warrant an interference. ಅದನ್ನು ಮಾಡಿ resultantly order ಮಾಡಿ dismiss ಮಾಡಿ. Yes. Pass out the
Four matters. Number one, issue Muchidi.
Called again in the afternoon, learning council for the petitioner had filed a memo seeking conversion of this criminal revision petition into a criminal petition. It also has raised an office objection regarding the maintainability of this criminal revision petition. In view of the office objection raised by the registry, the memo filed today and the supporting submission made by the learned counsel for the petitioner, the petition, the permission as sought for is accorded. The registry is directed to convert this criminal revision petition into a criminal petition. However, subject to the further scrutiny to be made by the registry in the matter.
Case number 13, Ramesha H.
Jeopardy. ಹಾಳಾಗಲಿಕ್ಕೆ ಪ್ರಮುಖ ಕಾರಣರು ನೀವಿದ್ರ ಎಲ್ಲದನ್ನು ಪಂಚ್ ಮಾಡಿ ಹೋಲ್ ಮಾಡಿ ಕಟ್ಟಿ ಮತ್ತೆ ಅದನ್ನ ಕಿತ್ತು ಮತ್ತೆ ಎಳೆದು ಒಂದು ದಿವಸ ನಿಮ್ಮದು ಎಜುಕೇಶನ್ ರೆಕಾರ್ಡ್, ನಿಮ್ಮ SSLC ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡು, ಡಿಗ್ರಿ ಸರ್ಟಿಫಿಕೇಟು ಅವನ್ನೆಲ್ಲ ತಂದು ಅಲ್ಲೇ ಇಟ್ಟು ಸ್ಟಿಚ್ ಮಾಡಿ ನಾನು ಹೇಳ್ತೇನೆ ಕೊಡಿ. ಅವಾಗ್ಲೂ ಇದೇ ರೀತಿ ಪಟ್ಟ ಹರಿದು ಪಟ್ಟ ಅಂತ ಕೊಡಿ, ಅವಕ್ಕೂ ಹೋಲ್ಗಳನ್ನು ಮಾಡಿ ನಿಮ್ಮ ಹೃದಯಕ್ಕೆ ಚುಚ್ಚಿದಾಗ ಆಗ್ತದೆ. ಆ ಸರ್ಕಾರಿ ದಾಖಲೆಗಳು ಅಂತ ಹೇಳಿಬಿಟ್ರೆ ಹೇಗ್ ಬೇಕಾದ್ರೆ ಹಾರಿಸ್ಬೋದು. Called again. The counsel for the petitioner submits that the needful is done in the matter. Registry also has made a note to that effect on A1/22. The matter is about what? What this revision petition 138, confirmation of conviction. Whereas Ray 1/20, wherein the petitioner has sought for bringing the alleged legal representatives of alleged disease, sole respondent. Next, an issue emergent notice to the alleged legal representatives of alleged deceased respondent. Main petition as well on IA 1/22. Where the necessary process and furnish copies in the registry within a day from today. Present notice as return number by 14. For yes.
Number 15. Ram Prasad is said.
Process ಜೊತೆಗೆ ಮತ್ತೇನು ನಿಮಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿತ್ತು ಕೊಟ್ಟಿದ್ದೀರಿ. Learned counsel called again in the afternoon. Learned counsel for the petitioner submits that the cost ordered this morning has been paid and he has also taken. It's the matter. Register to verify and proceed further. Yes.
Number 42. Satyanarayana HLK. Further as for respondent.
None appear. As finally, a short accommodation is granted for the parties to proceed further in the matter. Wish the matter in the next week.
Number 43, Sri Vishwajit Rai M, Sri Cyril Prasad Payas.
Evidence led was separate in all the three matters, right? Evidence led was separate.
Common judgment was passed on the three cases.
Yes, common judgment. Yes, exhibits were marked in 3 sets.
Yes. 1, 2.
Evidence was common,
Evidence.
single.
Separate.
Tegiri, evidence. Tegiri. Murudu tegiri. Yes.
Okay. Petitioner method as well as the accused method, they were working in different biometric companies. In Bangalore. Both were colleagues method, and they were according to the prosecution, they knew each other and they were friends. Accused number 1, accused method wanted some money method, so he approached the complainant. And according to the complaint method, he has totally given a sum of 80,000. 80,000 was not given in full. First, he gave in small denominations, total 80,000 was. So he insisted for the repayment of the money, so I gave 3 checks. One
So
check-
loan is single.
Loan is single.
Loan is single. Repayment in the form of 3 checks.
Yes.
Okay.
First check was for 10,000. Dated 20th August 2009. Other check was 90,008 for 20,000. And the other check was dated 25/9/2008 for 40,000. Even the checks were present in my according to complaint. It was not honored on the ground that I had made a request to the bank to make stop payments. Check was not honored. Thereafter, he issued me a notice. Exhibit 3, notice, stating that you are in due, my love, then you requested for the payment of the amount. I issued my love, reply, my love. Reply, my love. Reply, my love, I stated my love. We have transaction was completed by the case. What he said in his reply was that my love, he has paid the entire amount installments to the complainant, and the checks were given as security, my lord, and he has received the checks, my lord, in spite of paying the entire money. Total, my lord, around 1,46,955 was paid by me from 1998 to 2004. Side of the reply, my lord, by G, my lord, stating that I have paid the entire amount, files a case against G, my lord, and evidence was ready. 3 checks, my lord, as well as the legal notice as well as the reply notice was produced by him. What below, my lord, I put as the first instance, my lord, convicts me, my lord, for the said offences. Against, my lord, I have preferred an appeal for 3 appeals, my lord.
You did not lead evidence.
I led evidence.
You have led evidence.
Yes, I led. I have not, no documents were not on my side, but I did let in my evidence also, my lord, I have clearly stated, my lord, that checks were given as I admitted the transaction. 8,000 was agreement, but what I would say in my cost was that entire amount was paid by me. Installments from 1998 to 2004. The checks were given as security, my lord, and he has paid a sum of 1,46,995. Every month he used to make payments, my lord. The appellate court, my lord, holds that confirms the order passed by the order of conviction passed by the trial court.
Your defense is only that loan is admitted, but it was repaid.
Repaid, and the checks were given as security.
Security.
Security, even, if your lordship could take the cross examination of BW1 matter, the complaint, he has paid 80,000 in full. But actually, according to the evidence, he has not paid 80,000 in full. At once, he pays in small amounts. But the transaction of 80,000, I admit in the.
That is true. In that being the case,
Yes.
whether rightly or wrongly or legally, illegally, or whether for bona fide or with ulterior motive, the other person has withholding your check.
Yes.
And he is the drawer of the check. Undisputedly, those checks, when presented for realization, have returned unpaid.
Yes.
Admittedly, he has issued a notice to you. You have replied to the notice.
Yes, I have
Replied to the notice.
contention which I took was that three main contentions I took. One was that the checks were issued as a security. That he has misused those checks.
No, whether that defense is valid as on date, is it not the present position? Is that assuming for a moment that you had issued the check, but still one check is bounced, you are liable, or you have to rebut the presumption?
No. At present, my lord, that is correct, my lord, but at that time, my lord, probably I would have that defense, my lord.
Yes, that was the most common defense.
That was the common
Yes.
defense, they will check it.
Yes.
Holds, my lord, you have to check that liability is admitted, and I have not produced any documents to show that I have made any repayments. Court will holds that absolutely there is no document, but the trial court, my lord, may I just.
Please.
The trial court mainly convinced me. One of the main reasons for convicting me was I had issued some checks to other persons. Those checks got bounced. Series of cases were filed against me. So I was in the habit of issuing checks. That
Yes.
my submission was that, my lord, that could not have been taken as a basis for conviction.
That cannot be the sole basis.
Sole basis. But
That has got nothing to do. Fine.
Other transaction.
Yes.
I filed appeal, my lord. Appeal, my lord, the appellate judge, my lord, holds that though he was in the habit of issuing checks, my lord, that cannot be a reason to. But there are other circumstances stating that we have admitted the amount in question, my lord, 80,000 was admitted. Receipt of amount was admitted. The contention was that, as I said to your lordship earlier, my lord, the three main defenses was that I had paid the amount, security, checks were given as security, my lord, and from 1998 to 2004, I have paid the amount per month, my lord, which comes to around 1,46,955.
Fine. Say the first point, what you can was the trial court held that he was an habitual offender in the habit of issuing the check.
Checks, and I was convicted.
And he was convicted.
In one case.
That was not considered by the first appellate court.
Yes.
The first appellate court said that that is not a proper reasoning. But however, the fact remains that the first appellate court confirmed the conviction.
Yes, sir.
By observing that there are other
Yes,
evidence
yes,
to show that you have committed the guilt.
yes.
Therefore, your point that the trial court has held erroneously is not available to you, because that has already been considered and answered in your favor by the Sessions Court, despite which your conviction was confirmed. Then what else is your point of argument? Yes. Then, since both of you admit clearly and categorically that you were colleagues at one point of time, working together in Kudramukh Iron Ore Company and known to each other, and the accused has fairly conceded the financial transaction with the complainant, but it takes a contention that the checks in questions were not given as a repayment of the loan, but as a security. However, that he has repaid the amount to an extent of 1,46,955.
Yes.
The truth would be to the knowledge of only to the parties, accused and the complainant. Did you in that regard inquire your client, that is the complainant, as to whether it was true that he has paid some amount of the entire amount? Otherwise, why he should admit the liability and contend that say I have paid 1,46,000 rupees to him? Adinenadru kelidra neevu nimmarna?
He has paid. It's the only defense he has taken, my lord, before the trial court. And the trial court, as well, the first appellate court, not to use any document to prove that.
ಅದು ಬಿಡಿ, ಅದು ಕ್ವಶನ್ ಆಫ್ ಪ್ರೂಫ್, ಅಪ್ರಿಸಿಯೇಷನ್ ಆಫ್ ಎವಿಡೆನ್ಸ್, ಅದಕ್ಕೆ ಆಮೇಲೆ ಬರುವ. ಈಗ ನಾನು ಕೇಳ್ತಾ ಇರೋದು ಕಾನ್ಶಿಯನ್ಸ್ ಆಫ್ ದಿ ಪಾರ್ಟೀಸ್, ಕಾನ್ಶಿಯನ್ಸ್ ಆಫ್ ದಿ ಪಾರ್ಟೀಸ್. ಸೊ ಕಾನ್ಶಿಯನ್ಸ್ ಆಫ್ ದಿ ಪಾರ್ಟೀಸ್ ಏನ್ ಹೇಳ್ತದೆ ಅನ್ನೋದು. ನಿಮ್ಮ ಪಾರ್ಟಿನೂ ಒಂದು ಹೇಳ್ತಾರೆ, ಅವ್ರ ಪಾರ್ಟಿನೂ ಒಂದು ಹೇಳ್ತಾರೆ. ಸಾಮಾನ್ಯ ದಕ್ಷಿಣ ಕನ್ನಡದವ್ರು ಆ ಪಾರ್ಟಿ ಸುಳ್ಳು ಹೇಳೋಲ್ಲ ಅನ್ನುವ ನಂಬಿಕೆ ಒಂದಿದೆ. ಅವರು ಬೊಬ್ಬರಿಯ ಪಂಜುರುಳಿ ಎಲ್ರಿಗೂ ಚೂರು ಹಂಚ್ತಾರೆ. ಮಂಜುನಾಥಿಗೆ ಸಾಕಾಗಿದೆ ರೀ, ಎಲ್ರೂ ಅವ್ರ ಆಣೆ ಇಡೋರೆ. ಏನ್ ಮಾಡ್ತೀರಿ? ಮಂತ್ರಿಗಳು, ಮಾಜಿ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಇಡ್ತಾರೆ. ಯಾಕೆ ಕೇಳ್ತಿದ್ದೇನೆ ಅಂದ್ರೆ, ಹಾಗೇನಾದ್ರು ಆದ್ರೆ the order should not be harsh to either of the party, because appreciation of evidence is something different. In these 138 cases, what actually has happened behind the scene is a different thing. And those aspects would be to the exclusive knowledge of the parties only, not even to their respective counsels, not even to their respective counsel. Therefore, if the contention of the accused in the instant case, if inspires some confidence, not to suspect it, I'm not using the word to believe it, not to suspect it outrightly, then ಒಂದು ಸರ್ತಿ ಇಬ್ಬರು ನಿಮ್ಮ ಕಕ್ಷಿದಾರರಿಗೆ ಸತ್ಯ ಏನು ಅಂತ ನಿಮಗಿಬ್ಬರಿಗೆ ಗೊತ್ತಿದೆ, ಸುಳ್ಳು ಹೇಳಲಿಕ್ಕೆ ಹೋಗ್ಬೇಡಿ. ನೀವು ಅವ್ರ ಮೇಲೆ ಆಣೆ ಇವ್ರ ಮೇಲೆ ಆಣೆ ಅನ್ನೋದು ಬಿಡಿ. ನಿಮ್ಮ ಆತ್ಮಕ್ಕೆ ನಿಮಗೆ ಗೊತ್ತು, ನಿಮ್ಮ ಆತ್ಮಕ್ಕೆ ನಿಮಗೆ ಗೊತ್ತು. ಹಾಗಾಗಿ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ, ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ, ಪೂರ್ತಿ ಕೊಟ್ಟಿದ್ದಾರೋ, ಭಾಗಶಃ ಕೊಟ್ಟಿದ್ದಾರೋ, ಅವ್ರು ಅರ್ಧಂಬರ್ಧ ದುಡ್ಡು ಕೊಟ್ರು ಅಂತ ನೀವು 3 ಚೆಕ್ ಇಂದ ಹಾಕಿದ್ದೀರೋ, ಅಥವಾ ಅವ್ರು ಪೂರ್ತಿ ದುಡ್ಡು ಕೊಟ್ಟರು ನೀವೇನಾದ್ರೂ ಹಾಕಿದ್ದೀರೋ, ಅಥವಾ ತಪ್ಪಿಸ್ಕೊಳ್ಳುವ ಒಂದು ಮಾರ್ಗವಾಗಿ ಅವರು ಈ ಡಿಫೆನ್ಸ್ ಅನ್ನು ತಗೊಂಡಿದ್ದಾರೋ, ಅದನ್ನ ನೋಡಿ. ವಿ ಲೀವ್ ಇಟ್ ಯುವರ್ ಕಾನ್ಶಿಯನ್ಸ್ ಅಂಡ್ ಕ್ಯಾನ್ ಅರೈವ್ ಇಟ್ ಎನಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಏನಾದ್ರು ಈ ರೀತಿಯಾಗಿ ನಿಮ್ಮ ಕಕ್ಷಿದಾರನ ಇಬ್ರು ಕೇಳಿದ್ರ?
Last time, that was argued for quite a few minutes. Then your lordship suggested, my lord, why can't you?
Yes.
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 I requested, I called him. He's only thing he said was, my lord, I have paid the entire money. You argue the case.
ಅಲ್ಲ, ಅದು ಛಲ. ಅರ್ಧ ದಕ್ಷಿಣ ಕನ್ನಡ ಹಾಳಾಗಿರೋದೇ ಛಲದಿಂದ.
Furthermore, as a professional, my lord, I could not advise you.
ಹೌದು ಹೌದು, as a professional cannot.
I could not.
Cannot.
He said you argue the case because I have satya ಬಂದ್ರೆ ಬರುತ್ತಂತೆ. And I said I believe.
ಪರಿಣಾಮ ಹೇಗೆ ಆಗ್ತದೆ ಹೇಳಲಿಕ್ಕೆ ಬರಲ್ಲ. ಇಬ್ಬರಿಗೂ ಅದು ಸಮಂಜಸ ಅನ್ನಿಸದೇ ಇರಬಹುದು.
They are not from South Canada. They are from ಬೇರೆ listeners. They are not exactly from the.
ಅಲ್ಲ, ಅವ್ರು ಗಾಳಿ ಕುಡಿದ ಸೌತ್ ಕೆನರಾ ಉಪ್ಪು ನೀರಿಂದಲ್ವ?
They were working in South Canada.
ಆ ಗಾಳಿ ಬದಲಾಯಿಸ್ತದೆ. ಸ್ವಲ್ಪ ಅವ್ರೇನಾದ್ರು ಅಮೌಂಟ್ ಅನ್ನ ಸ್ವಲ್ಪ ನಿಮ್ಗೆ ಹೇಳಿದ್ರು, ಅವ್ರೇನಾದ್ರು ಅಮೌಂಟ್ ಅನ್ನ ಕಂಪ್ಲೇನೆಂಟ್ ಸೈಡ್ ನವ್ರು ಅಮೌಂಟ್ ಅನ್ನ ಏನಾದ್ರು ಸ್ವಲ್ಪ ನಾನು ಬಾರ್ಗೇನಿಗೆ ಕಡಿಮೆ ಕೊಡ್ಲಿಕ್ಕೆ ಹೋಗ್ತೇನೆ ಅಂದ್ರು ನಿಮ್ಮ ಕಕ್ಷಿದಾರ ಸಿದ್ಧರಿಲ್ಲ. ಹಿ ಇಸ್ ರೆಡಿ ಟು ಫೇಸ್ ದಿ ಜಜ್ಮೆಂಟ್.
You argue the case. Then furthermore, I could not. Because otherwise they would mistake us.
Yes, yes. No, you cannot say go beyond that. You cannot pressurize him or. Yeah.
The suggestion came from the court.
Oh, yeah.
Your lordship said, why can't you?
Yes, yes.
Amount is small.
Yes.
I can't use it. And your lordship had given a sufficient date also for this.
Yes.
Yes. That's all my lord. Apart from that. So the question was put to the complainant, my lord, because he was having a salary of just 25 to 30,000. And he was an income tax agency. Only to show that he would not have such an amount to give, my lord, 80,000 to 20,000. Left at that stage only, my lord. Just the sentence was, suggestion was put to him that, he was drawing the salary of 28 to 30,000 and he was an income tax excess. What he says, paragraph 11 of the is cross examination.
PW1 or DW? PW1. Yes.
What is, I have given the amount not as the loan. What he clearly says that whenever he asks money, I will give him money, but not as a loan. ನಾನು ಆರೋಪಿಗಳಿಗೆ ಹಣವನ್ನು ಸಾಲ ಎಂದು ನೀಡಿಲ್ಲ. ಆದರೆ ಸ್ನೇಹಿತನಾಗಿ ಅವರು ಹಣ ಕೇಳಿದಾಗ ಹಣ ನೀಡಿದರು.
But he himself has stated that say towards the repayment of the amount, 3 checks were given.
Because he admit, the first stage was the legal notice. I replied. Reply only he admits.
The very first threshold itself,
Yes,
you have admitted.
yes, I have it. I can't go beyond that.
Yes, yes. Good. Good. Okay, then, common. The summary of the case of the complainant in the trial court in these cases are that the accused in the same establishment, that is Kudramu Kairanu company. Limited, and that they were known to each other. At the request of the accused, sum of rupees 80,000 was given by the complainant to him to discharge his alleged debts. Towards repayment of the same, the accused got issued in 3 checks bearing check number, date, PW1, examination chief legal. For a sum of rupees 10,000, 30,000, 40,000, all the checks drawn in favor of the complainant on State Bank of India, Panambur, Mangalore. The such checks were presented for realization, the same returned unpaid with the banker Shara as payment stopped by the Roy. Thereafter, the complainant got issued a legal notice upon the accused demanding the payment of the check amount. However, the accused, instead of paying the check amount, paying the check amount, sent an untenable reply, which constrained the complainant to institute a criminal case against him in the trial court for the offence punishable under Section 138 of Negotiation Instrument Act. Criminal parable, the appropriate place in the case. The parties to all these 3 cases are same parties. For the alleged dishonor of 3 checks, the complainant has filed 3 criminal cases, Section 138 of NI Act, which ended in conviction, and the same was further confirmed in criminal appeal filed by the accused in the Session Judges Court. As such, these 3 criminal revision petition has arisen at the instance of the accused. Might I have a moment? Please. Yes, yes.
Formal conviction was passed under the respect of all the cases. The appellate court notifies stating that you can't have a formal conviction. First 3 different convictions.
So the appellate court still confirmed it.
Yes, still
confirmed it. And counsel for the petitioner in his argument submitted that the trial court has committed an error by basing its judgment of conviction on the alleged antecedent of the accused, who was said to have issued few more checks to other persons and in couple of matters had suffered the judgment of conviction. Further submitted that PW1 has not specifically stated that the amount alleged to have been given to the accused was in the form of a loan, has only called the alleged transaction as the amount given to the accused at his request. Per contract, the counsel for the respondent submitted that the reasoning of the trial court, one of the reasoning of the trial court that the accused was a habitual offender, was in the habit of issuing checks and facing the criminal trial punishable under section 138 of NI Act, was discussed by the Session Judges Court in the appeals filed by the accused, and which First Appellate Court, even after observing that the said reasoning was not convincing, still confirmed the conviction, holding that there wasn't evidence to prove the alleged guilt against the accused. It also submitted that the very act of the accused admitting the loan in his reply notice, and further his unestablished contention that he was paying the interest on the loan, on the amount received by him, would itself go to show that it was a loan transaction. Furthermore, loan transaction. This is submitted that the impugned judgment does not warrant any interference at the hands of this court. It is not in dispute that both the parties to the litigation are known to each other. The complainant as PW1 and the defendant and the accused as DW1 have in their respective evidence stated that both of them were known to each other and they were colleagues working in the same factory. It is also not in dispute that the checks in question, which are marked at exhibits, P1 in all the three cases separately is drawn by the accused. It is also not in dispute that when presented for realization, all those three checks returned unpaid with the banker's endorsement that the payment was stopped by the drawer. The said aspect of dishonor of the check is further corroborated by the banker's endorsement at exhibit P2 and P3 in CC number 182 of 2009 and 183 of 2009, and by exhibit P2 in CC number 184 of 2009. Further, it is not in dispute that demanding the payment of the check amount after their dishonor, the complainant got issued legal notice upon the accused. The same is evidenced through the postal receipts, postal acknowledgement, and the copy of the legal notice produced and marked as exhibits by the complainant in all these three cases. It's also not in dispute that in response to the notice received by him, the accused sent AAA as evidenced in exhibit P7 in CC number 182 of 2009 and CC number 183 of 2009. Therefore, A presumption about the existence of legally enforceable debt forms in favor of the complainant. Section 139 NI Act, however, this presumption is rebuttable. In order to rebut the presumption, the accused has taken a specific defense in the cross-examination of PW1 in all these three criminal cases, that the checks and questions were issued by him to the complainant only as a security when he had some financial transaction with the complainant earlier. He also took a defense that the alleged liability by him towards the complainant has been discharged by him by repaying a sum of rupees 1,46,955. 955. You paid it.
He also took a defense that the alleged liability.
The entire amount of rupees 1,46,955 has been paid by him to the, in order to substantiate his defense, the accused not only made suggestions to that effect in the cross-examination of PW1, but entering himself and examining himself as, but by examining himself as DW1 in all these three cases, he reiterated his defense. However, PW1 did not admit the suggestion made to him as true and made and denied the evidence of DW1 given in his examination in chief by making appropriate suggestions in the cross-examination of the witness. As such, the defense of the accused that he had paid a sum of rupees 1,46,955 has confined only to his oral statement uncorroborated with any documentary proof. Subcategory. In addition to the above, DW1 in his cross-examination has specifically stated that he does not know as to in how many installments of what amount he has paid the alleged sum of rupees 1,46,955 to the complainant. Had he really repaid such a huge amount to the complainant, definitely he was expected to give some more details about his alleged repayment of the amount to the complainant. On the contrary, the accused himself at the very first instance, that is in his reply notice, has acknowledged the receipt of a sum of rupees 80,000 from the complainant by him. In the very opening sentence of the reply notice, the accused has stated that he had borrowed in all rupees 80,000 on various dates during 1998-2004 from the complainant. Thus, when he himself has admitted a receipt of rupees 80,000, that too by calling it as a borrowal. The contention of the learned counsel for the petitioner that PW1 has not called the said loan transaction as a loan is not acceptable. This is also for the reason that the very same complainant as PW1 has stated that towards the repayment of the amount, the accused had given him 3 checks, which are the subject matter of these 3 litigations. Had this not been a repayable amount or a borrowal made by the accused, the complainant would not have called that receipt of those 3 checks were towards the repayment of the amount given by him to the accused. As such also, the defense of the accused not in any manner rebut the presumption formed in favor of the complainant. On the other hand, the presumption that was already formed in favor of the complainant under section 139 of NI Act crystallizes further. Thus, it is appreciated in this aspect since the trial court has convicted the accused for the alleged offense, which was further confirmed by the session judge's court, I do not find any reason to interfere in it. The petitioner or the accused has, for the proven guilt, sentenced to undergo, sentenced to pay a fine of rupees like 33,000 in CC number 182 of 2009, and in default to undergo simple imprisonment for 1 month, 45,000 in CC 183, default simple imprisonment 1 month, CC 184 of 2009, fine of rupees 12,000, default 1 month. Sentencing policy, no need to interference. Resultantly, the criminal revision proceed to pass the following orders. Criminal revision petitions number so and so, so and so, so and so, dismissed as devoid of merits. Registry to transmit.
Number 44, Sayyid Khalil Pasha for petition number 1 and 3, Giridhar H for respondent.
An affair in the matter either physically or through video conference. No reasons are forthcoming for the non-appearance. The result of the order sheet will go to show that observing the absence of the learned counsel for the petitioner and not pursuing the matter, this court on 1/4/2022 had issued a non-available warrant against the petitioners. However, the instance of the petitioner, by allowing the year 1/2022 on a cost of ₹2,000, warrant issued against petition number 1 was recalled 21/4/2022. Even thereafter also, thereafter, when the matter was again listed on 21/11/2022, the learned counsel for the petitioner alone was present and submitted that petition number 2 died 21/11/2021 and took an adjournment to do needful in the matter. Though the time was granted, till date the petitioner has not done needful, nor even appeared and proceeded further in the matter. He has also not shown any reason. He has not even prayed for any further time to do needful in the matter. Hence, though the criminal revision petition would not be generally dismissed for non-prosecution, however, the present revision petition is the one filed in the petition under section 12 of DB Act, the expansion version 19. DB Act. I do not find any embargo for dismissing the petition prosecution. Hence, the petition stands dismissed for non-prosecution.
Bill number 45, Sri Prasanna Kumar P, SPP for respondent.
What for? Request of the learned counsel for the petition. Each time a spread is granted. Yes.
Bill number 46, here, Sri PB Ajay.
It appears that probably the revision petition may not be maintainable. At the, as at the time when the revision petition was filed, it was considered as maintainable. But during the pendency of this revision petition, it appears that there is a judgment of the Honorable Apex Court, observing that no revision lies against any order passed in an appeal under section 29 of the DBI. So the registry is raising objection on all the pending matters also regarding the maintainability, and the learned counsels are seeking the permission for conversion. Seeking permission for conversion. Look into that aspect. I will adjourn the matter by a week. If you are convinced that it is not maintainable, then you are at liberty to do needful, including seeking conversion. Learned counsel from both sides present.
The husband also has filed one more revision. There's a connected matter in the child petition. They have to.
Both
Yes.
the revision petitions. It may become at the maximum a criminal petition. Learned counsel from both sides present. Admittedly, as submitted from both sides, both the criminal revision petitions have arisen from out of the impugned judgment passed in a criminal appeal filed under section 29, the Domestic Violence Act. In the view of the matter, registry to re-scrutiny the petition regarding its maintainability. List the matter in the next week. You want any particular date, or shall I just call? Yes. Shall we have it on 6th December?
I'll be out of station.
8th December. On that day, if you are convinced that say it is not maintainable, come up with a respective memo, different separate memo, and ensure that the learned counsel who signs the memo should hold the wakalat. Otherwise, some junior, a new entrant in the office, if he signs, that may cause some more delay. Yes. Yes, 9. 9.
City number 47, Sri Lokesh Kumar case for petitioner Chetan B for respondent.
Yes.
Yeah, the same counsel. Even I sent the photographs and video of the present position of the petition. And he told, he asked me to give the receipt which we have paid before the trial court.
The counsel for the petitioner alone present and submits that the settlement attempt is in progress.
There also a letter was written by the present petitioner stating that initially and loan could a loan of the State Bank of India. Sala ಉಪಯೋಗ ಮಾಡ್ಕೊಂಡ್ರಿ ಅಥವಾ ದೇಶ ತಗೊಂಡ್ರಿ ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ನಾನು ಮುಂದುವರಿಸಬೇಡಿ ಅಂತ ಹೇಳಿ he has given letter to the opposite advocate on 15/22/10.
That we will consider in case of necessity to proceed on merit. Since the settlement process which was initiated at the advice of the court on the previous date of hearing is in progress. So since he has given some hope that give me the details of deposit made, I will consider. Or probably he may say, I am happy with this deposit. Or he may say, I want something, some more amount in addition to this deposit. So if that is agreeable, fine. Otherwise, we'll proceed on merit. And at that time, you can draw my attention to Exhibit P8. We will hear the other side also.
Submits that the settlement of it is in progress.
Okay. And praise for a short accommodation. Declare counsel for the respondent not present. List the matter on 7th. At 7th, probably since this morning you are the 14th or 15th person. On 8th, 2022.